Memo has been filed not to proceed with the matter. Memo be kept on record. Requisitions were dismissed as not pressed.
Prakash Kumar Mahanti.
Pardon?
On behalf of Mr. Prakash Mahanti, my lord. I counsel for the petitioner, my lord.
Yes.
The application, my lord.
Yeah, why are you not filing appearance memo? Even day single appearance also there is a memo.
My lord, I'm sorry, my lord.
This is for a company.
My lord.
Company may create problem tomorrow. We had not authorized such a counsel to argue.
Okay, my lord.
So why are you taking risk?
There's also defect, my lord. I removed the defect, my lord.
You are arguing or adjourning?
I'll file the defect. I'll remove the defect, my lord.
Don't run that risk.
Well, I'll defect.
Otherwise, suppose
Then we create problem, my lord.
then the company may blame you. Why is taking such risk? After vacation.
For orders, item number 3.
I am for the petitioner. On 8th, when your lordship directed notice, I remained under the impression that your lordship allowed time till 10th for filing requisites. So I filed.
If you file late, be accepted. Office is directed to notice according interim order to continue. Your writ was entertained in 2023, still you are neglecting.
No, mass, I thought lordship said day after tomorrow, but it was actually tomorrow. So
That impugned notification has also been quashed, your lordship. By impugned notification has already been quashed by an honorable single judge. And that has, my lords, and that has already been.
my lord, that
Close kar do taale.
যেহেতু TPCODL ନୂଆ ପାର୍ଟି ହେଲା ସେଟାই lordship wanted to issue notice to TPCODL only.
TPCODL is not the petitioner.
No, my lord.
But what is the necessity of hearing them if the
My lord, because the government notification is.
In which order? In which order? Where is that single judge order?
Lordship, that is.
Lord, it is covered by that your lordship's order, my lord. A covered case, my lord. That franchise engineer may not be act as assessing officer.
Okay, all right. Then we have passed that order.
That notification was quashed, my lord.
Notification was passed.
That notification was quashed, my lord. Only liberty, my lord. Basing on this verification report by the verifying officer.
I will file both the judgments. Single bench.
Licensing proceed under 126 fresh, my lord.
Let us place the case.
Single bench as well as writ appeal order.
In hand. Anantu, apno dita ka order हमको आनंद notice को.
I have the citation here if lordship wants. My lord.
Lordship may call this matter along with 18465 of 2016 connected matter same. 18465 of 2016.
Tomorrow. You just give it in a memo.
Lordship.
Or in a sleep at least.
Lordship.
Yes.
Obliged.
See, simply order tomorrow. Interim order to continue till tomorrow.
For admission, item 4.
May it please your lordship.
Yes, 4. दियंतु सेट रे दियंतु स्पाइरल सेट देइचंती
आगे देच फाइल कर देच
काई नॉट हियर
एलसीआर बंधाई छी
नहीं तो आपको पत्र नहीं
Your lordship, 12th I have filed. As per it.
All right. Comments the argument. Yes. Yes, continue with your argument.
Right. Your lordship, I had filed a written submission also earlier also on the.
What is the challenge here?
Challenge is with regard to the award, your lordship. The annexer 14, page 326, your lordship.
Annexer 14.
14. Award
by
Award by the Industrial Tribunal, Your Lordship.
14.
I have filed a note, Your Lordship. May kindly refer to the
Just
note.
let us
Fine.
get the
Okay.
roadmap at least. What is the
Okay, okay,
challenge?
okay.
Who has
Yes,
to
yes.
ask? What is
Yes,
the
yes,
reference?
yes, yes.
Then we may go. to
I'll take your, that's why I was taking to your referral, Lordship.
the- Yes, NSO 15 is
14 is the award, Your Lordship.
the hour.
Again. Page 326. Start from 328.
Yes, what was the reference?
Reference, Your Lordship.
Management. Your management.
Yes, Your Lordship.
Hmm.
Reference, Your Lordship, is Annexer 2, page 47. Yes.
Yes, reference you can come to 327.
327, Your Lordship.
Have you filed the reference independently?
Yes, yes, yes.
Where is that available?
Annexer 2,
NSO 2 page
page 47, Your Lordship.
47.
47, 47.
Okay, now read.
Mal,
Read from page 47.
page 47, Your Lordship. Your Lordship, reference is dated 20th of September 2006, 29, 2006. May I take Your Lordship to the schedule?
Yes, reference for.
Yes, yes. Schedule is, there are 3 items of reference, Your Lordship finds.
Yes.
One, whether the demands of the union for onward revision of basic wages, public salary, dearness allowance, increments and allowances like LTA, conveyance allowance, special allowance, education allowance, tapping allowance, attendance bonus, washing allowances, night shift allowances and HRA are justified and need any upward revision. If so, what should be the details?
Yes.
Number 2, whether the demand of the union for payment of additional dearness allowance on the basis of All India Price Index 1960 base 100 is legal and oblique or justified. If so, what should be the details? Then 3, whether the demand of the union for time-bound promotion and rationalization of existing grades are legal and are justified. If so, what should be the details? These are the 3 items of reference, Your Lordship.
One is variety of service benefit.
Yes, yes. Wages, wage rise.
Number
Basic
2 is
wage rise and-
dearness allowance on the basis of All India Price Index.
Yes.
And
Third is
number
time-bound
3,
promotion and
promotion
rationalization.
and rationalization of existing grades.
Mark.
Yes.
And out of these 3, Your Lordship, the third item has been answered in favor of the management. Third issue, third reference.
Okay.
There was a
Promotion
challenge
and rationalization went in favor of the
Management.
management against the union.
against the union laws.
Hmm.
And they had filed a written writ petition also against this award, against that thing. They had withdrawn it subsequently. Your Lordship.
They have filed
Withdrawn it. That has been filed.
repetition number कितने?
Again. I think that is tagged, Your Lordship, but I'm giving the number, Your Lordship. Number. Number. Yes.
So 1 and 2 is challenge here.
5679 of 2014 WPC.
5679 of
2014. And that was withdrawn on 19/3/2015.
5679 of 2012.
14, 14.
14
Again.
and withdrawn on 19/3
2015.
15.
15.
Hmm.
Yes.
Okay, so therefore this is a repetition confining to
1 and 2.
reference 1 and 2.
1 and 2, Your Lordship. 1 and 2. And on these two, and the entire set of reference, Your Lordship, the written statement, claim statement was filed on 10/8/2007. I have annexed as Annexer 3. Then in reply thereto, the written statement was filed by the petitioner management, which is at Annexer 4. Then a rejoinder was filed by the union, and then a reply to the rejoinder was filed by the management. Sorry.
Those are annexures.
Annexers 3 to 6, Your Lordship. 3, 4, 5, and 6 pleadings.
3 to 6.
3 to 5, 3, 4, 5, and 6, Your Lordship.
The claim statement is annexure.
Claim
2,
statement is 3.
3.
Yes,
So 3, 4, 5, 6.
yes, yes, yes.
All right, yes. What was their claim? What was, how could you?
My lord, the
calculate and
issues have been
How
settled.
is the appreciation?
Your Lordship. Appreciation, Your Lordship. Your Lordship, just before I take to Your Lordship to the award, I must say that on behalf of the union, there have been 6 workmen witnesses who deposed,
Hmm.
and 27 documents with series were exhibited. I have also filed all the evidence, Annexer 7 and Annexer 8. Then the petitioner management, on behalf of the management, there have been 7 witnesses who were examined, and exhibit A to BB have been marked as documents, Your Lordship, supporting documents. And yes, 9 and 10, Annexer 9 and 10. Then Your Lordship sees the issues which is at page 330, starts from 330, Your Lordship. 330 and 331.
Page
330 and 331. Virtually, what have been the references? All the 3 references have been made out as 3 issues, Your Lordship. 330. Internal page 5 and 6.
300.
330 and 331.
Yes. Yes, 330.
330 starts
These are the issues framed by tribunal.
by the tribunal, Your Lordship. Virtually, it is as per the reference, Your Lordship. The 3 items of reference, they have been made the 3 issues, Your Lordship.
So that is just repetition.
Yeah.
That is just repetition of the
Repetition.
reference.
Your Lordship, repetition. Now, Your Lordship comes to page 331, findings, Your Lordship. Issue number 1, Your Lordship. The aforesaid issue relates to upward revision of basic wages, salary, DA, increment, allowances like LTA, conveyance allowance, special allowance, education allowance, tapping allowance, attendance bonus, washing allowance, night shift allowance, and house rent allowance. And now the land tribunal comes to the decision, Your Lordship. The Honorable Supreme Court, in the case of Hindustan Antibiotics Limited versus the Workmen, reported in 1967, 14 FLR 37, has held in para 9 as
Who
follows.
appears for workmen?
Mr. Rai. Mr. Rai.
You are there.
Yes. At the outset, it will be convenient to consider the question of principle. The object of the industrial law is twofold, namely, 1, to improve the service conditions of industrial labor so as to provide for them the ordinary amenities of life, and II, by that process, to bring about industrial peace, which would in turn accelerate productive activity of the country, resulting in its prosperity. The prosperity of the country in its turn helps to improve the conditions of labor. By this process, it is hoped that the standard of life of the laborers can be progressively raised from the stage of minimum wage, passing through need-found wage, fair wage to living wage. Industrial adjudication reflected in the judgments of tribunals and the courts have evolved some principles governing wage fixation, through, though accidentally, they related only to industries born in the private sector. The principle of region cum industry, the doctrine that the minimum wage is to be assured to the labor, irrespective of the capacity of the industry to bear the expenditure in that regard. The concept that fair wage is linked with the capacity of the industry, the rule of relevancy of comparable concerns, and the recognition of the totality of the basic wage and dearness allowance that should be borne in mind in the fixation of wage structure are all so well settled and recognized by industrial adjudication that further elaboration is unnecessary. In this context, a reference to the decisions in Messrs. Crown Aluminium Works versus their workmen, Express Newspapers Private Limited versus the Union of India, French Motor Car Company Limited versus workmen, and the Hindustan Times Limited New Delhi versus their workmen will be useful. There is no and there cannot be any dispute on the laudable aims of the industrial policy of our country in the matter of wage fixation. Dasgupta Justice in the Hindustan Times Limited New Delhi and their workmen said at page 240, in trying to keep true to the 2 points of social philosophy and economic necessities which vie for consideration, industrial adjudication has set for itself certain standards in the matter of wage fixation. At the bottom of the ladder, there is the minimum basic wage, which the employer of any industrial labor must pay in order to be allowed to continue an industry. Above this is the fair wage, which may roughly be said to approximate to the need-based minimum, in the sense of a wage which is adequate to cover the normal needs of the average employee, regarded as a human being in a civilized society. Above the fair wage is the living wage, a wage which will maintain the workman in the highest state of industrial efficiency, which will enable him to provide his family with all the material things which are needed for their health and physical well-being, enough to enable him to qualify to discharge his duties as a citizen. This passage briefly and neatly.
Anybody has the copy of this judgment?
My lord,
Full text of the judgment?
I have the book, your lordship. I can supply your lordship. I will supply your lordship.
Huh?
Instantly, I don't have a copy, your lordship, but I have the
You
book.
should have.
I'll supply.
Because
Definitely.
what happens here
Yes.
is,
Yes.
industrial tribunal is heavily banking on 3 of the judgments
Three judgments only.
and delivering his order.
Yes.
So
Yes.
therefore, whether those judgments were dealing in fact such issue
Yes. Yes.
or a general issue.
Yes. Yes.
No, what? Yes, Mr. Mishra.
Hmm.
You are a labor expert.
No. That's right. I understand your lordship.
That is
But-
the foundation. We want to know whether those cases were in fact helping this case or not.
That, yes. That is right, your lordship. But what I am humbly submitting, your
You
lordship,
just go on reading.
only 2 judgments only he has written, and your lordship finds at the end, your lordship, at page 18, your lordship.
Now, page 18, he starts comparing the profit loss.
Yes,
And
that is
then
the only
he
thing.
arrives, yes, there is loss, there is profit, and
So you give it.
you
The
say,
entire thing is justified and you
therefore,
give it.
that should not be as if we are writing
My-
essays.
My lord, exactly, that's right. That's what I wanted to just
No,
point
you
out.
don't advance argument in that way.
My lord. That was exactly I was going to tell your lordship, but because your lordship said that you place the judgment, that's why I'm placing it, your lordship.
No, we never intended to place.
I'm
judgment.
sorry.
You took us.
Acha, ठीक.
We wanted to know some backdrop of, unless we are clear what is challenge.
Backdrop
what was
which
the
I am saying,
reference.
because that's why I was taking your lordship to the brief note which I have filed.
No, you started reading from here.
My lord.
So therefore, where is those judgments?
Judgments, your lordship. What is it? Persisted.
Supreme
Your lordship, 948, your lordship.
Right paper, my lord.
AR 67 Supreme Court, 948, 948, your lordship.
Yes, AR 1967 Supreme Court 648. No. ये देख को फॉर्मेट पकड़ेगा ना हाँ ये 1967 Supreme Court 948
948, your lordship.
यार parallel SCR thibo, SCC, or settle SCR thala.
SCR thila bole. 67 SCR pay, volume 1, 652, your lordship.
SCC are convening.
SCR,
5 in is.
652, man. SCR.
Could you find from that judgment? The judgment.
Again,
You have a copy of judgment?
digital I am trying to take.
Upon I'm a case for you.
Sir, kota.
It is. to
There,
be seen-
there
it is to be
the
seen
basic
what was the
dispute was,
reference there.
Uh,
What we find here is,
yes,
that was simply a pay structure issue.
structure issue only. And what should be the parameters for arriving at a pay structure? That is only the entire thing,
So that is a
background.
glaring difference that.
Yes. Here the pay structure is not the issue, your lordship. The basic wage is there. Only they want a basic, some revision in the basic wage and the other allowances. The reference is specific, your lordship, in that regard. And are happy.
This is.
Only 30, only here initially when I was filed the repetition, 39 people were involved who had not signed the settlements. Now it has come down to 25.
That, was that a tripartite settlement?
Yeah, no, bipartite, your lordship, between the group of the workmen and the other union, another union and the management, your lordship.
Labor authority is not involved.
Yes, they have registered it.
Then how, then.
They have
you say
registered
it's
it.
Not a tripartite settlement?
No, no, it's not a tripartite settlement, bipartite, but got registered before the.
Form K is not there.
Form K is there. Form
K
K bipartite and got registered with the labor authorities, Your Lordship. Authorities have accepted that. That is, there are also exhibits in the case, Your Lordship.
So if this is implemented, will there be no discrimination amongst the employees?
No, my lords, we have offered them everything. And from 2018 onwards,
Not follow the question.
yes,
The question is just the reverse.
yes.
Question is just-
If this is implemented, then what about
Majority, there is.
majority agreement?
Agreement.
Will it be discriminatory
Minority,
in a way?
award is.
Our overturns all the agreements, Your Lordship.
But you answered. negative.
Yes, our overturn, that's what my case is. That since lot of
So
exhibit.
there will be amounting to discrimination in the majority
Yes,
class.
yes, yes. That is exactly my issue, my lord.
Therefore, yeah.
Settlement start from page
You're
250.
pleading involved that bipartite settlement at least.
At that point of time, the settlement was not there, Your Lordship, when the proceedings were going on. But subsequently it went on.
By the time award,
Award, yes, yes,
no, by the time award, the settlement was already.
yes, yes, Your Lordship. They have been exhibited.
They have been exhibited.
Yes. Your
And he
Lordship.
has not dealt with that.
No, 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 my lords. Unfortunately, not a single document has been. Annex 12, page 52, 51, Your Lordship may kindly see.
Then what is the pay these people are receiving
My lord, pay?
after the award?
Yes.
What is the pay these people are receiving?
There, as per the settlement, we have equated everybody, Your Lordship. As per the settlement, last
Award is not.
award is not, because that has been stayed.
There has been stay of the award.
Yes, yes.
It's not a. reinstatement
Only areas,
of 17B.
only areas are relating to to be decided, Your Lordship. But after the settlement, we have equated everybody at par, Your Lordship, from 2018 onwards. Yeah, I think that's the situation. What has happened, Your Lordship? This is relating to 3 years, Your Lordship. The 3-year period, Your Lordship, 2005 to 2007, Your Lordship. And thereafter also there has been another one reference to 2. One, there are subsequent reference from 2007 till date, Your Lordship. Another reference of the self-sum demands.
That is pending.
Yes, pending. Tribunal.
Definitely, once they have got an award, they will definitely be interested.
And Your Lordship sees, just a moment, Your Lordship, kindly see, page 251. Oh, yes.
Yes. 351.
251 is the settlement which is exhibit AA before the tribunal, Your Lordship. And Your Lordship comes to page 256. 256, Your Lordship.
In the Supreme Court judgment.
Point number 12, Your
In
Lordship.
the Supreme
I-
Court judgment, can you bring us to the reference?
Yes, I couldn't get you, Your Lordship.
The judgment of Gujarat, I'm sorry, that is Hindustan Antibiotics.
Come on.
What was the reference?
The reference was related.
Kindly find out that page and paragraph.
Yes.
Learned junior may.
Yes. Reference to. Your Lordship, it is in para 2 and subpara 4, Your Lordship. The company employs about 2,000 workmen, Your Lordship. Your Lordship gets it?
Paragraph 2.
Paragraph 2, subpara 4, Your Lordship. The company employs about 2,000 workmen.
Para 3.
Para 3.
Per 3 months, I'm sorry. A dispute arose between the workmen of the, I'm sorry, one. A dispute arose between the workmen of the company and the management thereof, and the workmen presented a charter of 15 demands to the company. The government of Maharashtra referred the said dispute to the industrial tribunal. Lordship.
And they have not taken down the.
Reference quote है ही नहीं. Yeah, it's a hiking touch, na? Yes. No, it's not quoted. No. Sorry. So I was referring your lordship to page 256.
No, please come back to reference again.
Reference, my lords. Reference is 47, your lordship.
So reference also involves.
Whether the demands of the union,
Basic wages and salary.
dearness allowance, increments and allowances
they are
like,
consequential.
yes.
So that is a dispute also involving basic wage and salary.
No, my lords, the basic wage needs upward revision. That's the last part, your lordship. Reference. Whether the demand of the union for onward
suppose-
revision of
suppose-
basic wages. Yes, yes,
Suppose,
yes,
and as the tribunal found,
yes.
there was requirement for upward basic wage and salary.
Because he says that you have got profit, you have got money to pay, so you pay.
Right. But that was probably the same issue there also in that Supreme Court judgment.
There the pay structure, fixation of the pay structure was the basic demand, your lordship, in those two cases, your lordship. That
What is
948 and
What
1175.
is the difference then?
Yes.
Here the language is onward revision of basic wage and salary. There fixation of basic. wage.
Fixation of,
What is the
yes,
difference
yes,
there?
Yes, my lord.
No difference virtually. And rest benefits are consequential. If Supreme Court in so many judgments have already took the consideration in a way, can we depart from that?
My lords, I was taking your lordship to page 256, that is the
The
settlement.
only question may come to be considered if there is a settlement with larger part of the
Yes, yes.
union
yes.
members.
Can that be outweighed, your lordship?
Can there be two sets of pay structure
Yes.
involving two sets of employees? Judgment dekhandu.
Yes, yes, that's right.
So you come to your statement of claim, written statement, where have you said
My lords.
that there was a tripartite settlement between the.
Tripartite settlement, your lordship, came after we filed the written statement. During the evidence,
Was it before the hour?
before the hour, yes.
Then what prevented you to not bringing that?
We have filed, your lordship. We have filed, we have proved that also during our evidence.
You have proved that.
Yes,
As
yes,
you
yes.
are saying.
Yes, yes.
There is the
Yes,
rejoinder,
yes.
other rejoinder, or affidavit to rejoinder.
No, affidavit evidence, your lordship. There was that.
Oh, there you have brought
Yes,
this.
yes, yes, yes.
Please take
Yes.
us to that.
My lords. Because I was just referring to your lordship to the page 256, because by virtue of these settlements, what the intending employees agreed, your lordship.
256.
Page 256, point number 12, your lordship.
Yes, just
Your lordship.
read.
The workmen agree that they shall not claim any favor or adjudication in the reference case pending before the industrial tribunal in ID case number 6 of 2006, and a copy of this settlement shall be filed in the said pending litigation for appropriate consideration of the Honorable Industrial Tribunal or at any other court of law as deemed fit, your lordship. This is the settlement which was signed by 182 persons, your lordship, whose names are also indicated in the
What is
subsequent,
this
at
is-
the end of the settlement, your lordship,
What is
enclosure
this?
1.
What is this?
My lord, this is the settlement, your lordship.
This is the settlement.
Yes, yes.
Okay.
This is marked as exhibit AA, your lordship.
How many pages? Ulta lagichi.
Again. It starts from 251, your lordship. This is 251, your
Okay.
lordship. No, from total. Yes. Two 52 is the joint application by the workman and the employer to the district labor officer for registration of the settlement, your lordship. And form K is
That
253.
Form K.
Yes, form K is 253, your lordship. And that continues till 294, your lordship. 294 is the last page, your lordship. And your lordship finds therein the last page. I'll take your lordship to page 294, which is enclosure 3 to the settlement.
This list doesn't contain name of these prisoners.
No, no, my lord, they had not signed, your lordship.
They are only of the agreed workmen.
Agreed workman, your lordship. And there is a table there, your lordship, at page 294, that existing scale of pay and the revised scale of pay of different grades, your lordship.
Yes, Mr. Roy. How many of these workers are still working?
I know at that time, reference period, there are 357 workmen, 357 workmen during the reference period, 2005 to 2007.
Hmm.
Out of 357, about 54%, I know, they are documentable. And let me kindly turn to page,
No, the bigger question involved here is,
yes,
if there is a bipartite settlement,
bilateral settlement.
and for them it is by union or workmen. notice.
That is not the.
Initially by the group of workmen, thereafter by the union, your lordship.
Union.
Not this union,
Not
there was another union, your lordship.
that reference period which the management signed with the workers representative. 5 representatives were nominated by the workers by meeting and given authorization that you will settle the matter with the management.
You never challenge that settlement.
No,
Their settlement, they have not exhibited through witness, Miller. That was not exhibited through witness. They only filed the document and that has been
Okay. if it
exhibited
has-
as with objection.
If it has come to life,
Yes.
then can it be ignored?
That my point is that settlement is not a settlement in the as
That
per
was never considered by the tribunal. That was never
they
considered.
consider, Miller.
No.
Settlement they are
No,
not
you
considered.
say that
My lord,
settlement-
my
that
lord, kindly
settlement
see
was
the
not
award, Miller.
exhibited.
Yes, my lord, kindly see the award.
before your lordship goes to that point, your
No.
lordship asked that question, that how many of the workers are there on roll, your lordship. I have indicated that also. There are only 9 workers on roll now.
Now,
9. And 16 have retired and 14 have taken the benefits during
But,
pendency of this case.
unfortunate part is, as he is saying.
My lords, I have given that document.
You have never involved this Form K in the evidence process.
Yes, your lordship, MW3, your lords, has said. MW3.
there is no
He says that's not a
witness
correct statement, your
No,
lord.
my lord, exhibit A and
MW3.
A, my lord, that is been exhibited with objection.
Court master, କଣ ଆଣିଲନି ତାଙ୍କ spiral bind ଆଣିଲନି ଭିତରେ? Accordingly.
Hello?
Prepare a further note accordingly.
Yes.
When you introduce the aspect of the bipartite settlement
Well,
and it involved union or only a representative of union
yes.
or workers,
Yes,
make it clear.
I'll make it.
And
I'll definitely make it.
at that time, only one
After
union,
all, it has been exhibited through
Yes,
management
yes, yes,
witness.
yes, yes.
Then what is the consideration by the tribunal?
No consideration, Your Honor. He has not touched it at all. Not touched it at all.
All right, I didn't talk to the tribunal. Also in the meantime.
Hmm, hmm. Good.
that is our page
Mr.
90.
Rai, you are referring to that Annexure 12, 251 to 310. The caption is copy of
Yes, yes,
settlements,
250,
exhibits
yes, yes.
AA and BB.
BB, that has been.
It has been marked as exhibits with
Exhibit-
objection. No,
with
that is well
objection,
taken.
yes.
Then MW proved that or stated that he has been cross-examined.
Yes.
No, this has not been examined through a witness, Miller.
Hmm.
My lord,
No. Mr. Rai, you see the difficulty. I mean, you are saying something diametrical opposite. The learned senior is saying that MW has stated. You are saying he has never examined. So,
Never examined.
so please
Never.
cross-check.
yes.
No, I am not saying right now.
Cross-check, we'll
Please
be
cross-check
checking
because
tomorrow.
this way we can't proceed. This way, if you
I
start,
understand.
I mean, everything is.
ଆଚ୍ଛା ଆପଣ
I
answer
mean-
ହଁ କହୁଛନ୍ତି ସିଏ ନାହିଁ କହୁଛନ୍ତି.
Diametrical.
So there is that.
And that's a pointed question from my lord.
Yes, yes. Miller.
There can be
My lord, may kindly speak
difference in factual
that last
aspect
week,
or admitted issues even. So we don't find any agreement anywhere at all. Somewhere he says, yes, you start saying, no, that's not there.
my lord, may kindly not pay 218.
No, you
218 Miller.
you just
That is clear.
you just prepare that.
Yes,
Just
yes.
prepare that.
I'll-
You have heard the because you'll be responding. He's yet to finish.
No.
So in your response, please. prepare that.
218, last witness was discharged on 20th July 2013, and exhibit A and A, exhibit BB, that was filed on 25/7/2013.
Okay, give us in a note. Give us in a note.
27 last week.
Even
Yes, yes,
assuming,
yes.
even
Assuming that
yes.
the existence is not denied, that's the other aspect.
No, that my point is that
No,
that said-
because if you say that he has never examined, he will say that now he has examined and cross-examined. So that kind of a scenario, please avoid.
yes, yes.
Then what the court can do? Will recall the witness or what?
No.
Then please consider that. We have to go by whatever the records
So
are.
what is the
So that last witness was examined on 20th July.
No,
And
but
that
also
document is filed on
We are not
25th.
discussing that. You please respond and you can very well respond.
Yes.
then there may be a question, Mr. Rai. Then there may be a question, if certain developments have been brought to the notice of the industrial adjudicator
Yes, Miller.
before the award is passed, could he have ignored that?
Correct.
And they have
And now the
discussed.
bigger question
Yes.
involved here is, if a set of employees, maybe larger in or smaller employee, have already entered into a agreement in Form K, and unless you challenge that Form K, whether that Form K will be binding you or not.
That is not binding because there is a bipartite settlement. Miller.
Bipartite settlement
Yes,
always
that
not
is only
binding,
binding to the
but
parties.
it has a consideration effect.
Consideration.
It may not be binding. You may argue that it is not binding. Law is also clear, it is
Yes, yes.
not binding, but it has a persuasion in taking a decision. Otherwise, you see, there will be discrimination
chaos, Your
between
Lordship.
two
Complete
same
chaos.
sets of employees
Yes,
in one establishment.
yes.
Only 57% employees got the benefit. They have settled the matter. 43% they have not signed. Not majority.
All right, let us see it further tomorrow. Kali.
मोटे नोट पे कर दे खाली नोट पे कर दे
Yes, in the meantime, bring those spiral bindings.
Yes. Launching it.
এটা কাগজ পাঠান। I didn't find. Tomorrow.
Also file the written note of argument.
Okay, please, sir, give me the citations. To court, Mr. Not the God boy.
citation
And those judgments, the tribunal has referred.
tribunal has referred to that AR 1967 Supreme Court 948
Hmm.
and then 1175 of the
Hmm.
same volume, Your Lordship. 67
Other one,
67 Supreme Court 1175
one,
1175
both the 1967.
both
Supreme Court.
67 both 67
He has taken down two judgments.
two
of-
judgments two
Two
judgments
judgments. Okay, all right, it has work patheba na.
again two
Copy
judgments.
pathe dam.
Two judgments.
Copy pathe.
Your Lordship.
Uttar Pradesh. Yes, next please.
Item 5,
Yes. এটা কার? এটা এই উনি use
This is a matter regarding that OERC order. On the last occasion, there were a number of cases which we are given by way of a memo. Those matters have not come.
Decision in this matter will not cover those cases.
Decision in this matter would cover, in fact. The entire order was the same, but no date was fixed. So that's how those matters have just fallen by the wayside.
The 2 years order.
OERC order also.
My
we
lords,
have-
I'm appearing for OERC. I've just received the file. If your lordships permit me, I'll take some time to seek instructions as to what.
To proceed or not?
Sorry, my lords.
To proceed or not?
Yes, my lord. My lords may, if your lords may give me 2 weeks' time to seek instructions.
Along with so and so. After vacation, along with so and so.
But is there any, I mean, their contention is not against adversarial. As
My-
far as you are concerned, they say that that OERC order covers everything. So nothing remains to be adjudicated.
OERC order in Tata Steel.
Tata Steel.
Tata Steel's order. I'll supply him copies.
Yes, if you can give me a copy of the order.
Can you take that instruction by day after? So it can be closed. There's no point in.
I'll try and take instructions.
So what we were proposing
The
is,
points are already covered.
Yes, my lords.
In a further decision of OERC.
Right, my lords.
Then nothing remain to be
Remains, my
considered
lords.
here. That's the short point.
If my learned senior just gives me a copy of that order, I'll check up and I'll.
It is claimed through Tata Steel judgment.
yes, Tata Steel, my lords. Tata Steel versus Oreda and Visa Steel also. Those copies,
Oh, Visa Steel also involved there.
yes, subsequent orders
In a
are there,
subsequent challenge.
my lords. That was also
Asked by-
reflected in the last order.
Yeah.
Last portion of the last order. if
And
my
in
lord
the
would-
meantime, why have you not taken instruction?
We have taken all the steps.
No, he has not taken.
I have
Last
just
order.
filed Vakalatnama last week, my lords. I've just received the file. Yeah, Mr. Naik was appearing earlier.
Even that IA for Energy Department also we have complied. Copies
Asked
also
by
we have.
the OERC in subsequent proceedings initiated by above companies. Has already covered. Issues already raised here. And there is nothing more to be decided here. Mr. Mishra, Gautam Mishra, Leonard, senior counsel appearing for. Years.
My lords,
The reference they do, through so and so and so. No. This court, on perusal of the order of the OERC in Research Steel Limited versus Florida, in case number 46 of 21. Finds Sri Mishra justified in claiming that issues herein is already decided with the para. Already 17.
There are three
Already
orders.
decided through the judgment oblique order of the OERC Bhubaneswar. Keeping this view, this court finds there is nothing further to be adjudicated. Recording such submission of Sri Mishra appearing for the petitioner, this court is closing the matter, finding nothing more required to be considered here, except observing parties will be abided.
My lords, I have a submission over here. This
Parties
order,
will be abided by this.
my lords, this order seems to be for FY 2015-16 till 2021.
Subsequent issues.
Yes,
but
yes.
involving same question.
Same principle.
So, please
So,
don't drag on litigations.
There are three orders.
Petitioner is saying
Very well.
issues are already covered by this judgment. He doesn't want,
Very well, lords, very well.
and you want adjournment.
No, in any event, Mr. Satyakam, you are
Yes,
not
ma'am.
agreed by this one, this
Yeah.
thing, or you have challenged it.
No, my
As far
lord,
as
I-
OERC is concerned, they have no role.
So there are three orders: Visa Steel, Tata Steel, and SAIL. I have given three orders.
Consideration process, this court also finds similar orders have been passed. In the case of SAIL Raulkela Steel Plant versus Florida, in case number 85 of 2021. The draft kari dekhe to.
And Tata Steel also I have given.
Tata Steel also there.
Yes.
Tata Steel ra judgment deychandi.
Visa Steel I have given, I think, extra
No,
copies.
one is SAIL,
One is Visa Steel, another one is Tata.
Tata kind.
Tata order.
Gotre dita lagi.
I'm sorry, I have been able to give one copy. I'm sorry for it.
So also in Tata Steel Limited versus Florida, case number 66 of 9. In view of the admitted position, in the subsequent decision of OERC through above three cases, issue involved herein has already adjudicated. There requires nothing more to be adjudicated in the writ application, which is disposed in terms of the decision. Order. The decisions taken of the OERC taken note herein above. ଏଗୁଡାକ ଚାଲିକି ନେଇ ଆସିବ ସ୍ପୋର୍ଟ ମାଷ୍ଟର
ଏଇଥିରେ ବି instruction ନିଅନ୍ତୁ ଆପଣ ଯୋଉ instruction ପାଇଁ ବ୍ୟସ୍ତ ହଉଛନ୍ତି ଅଛି there are sufficient cases to take instruction in a lighter vein of course.
My lords, deeply obliged.
So take a copy of that memo from the Lord
Yes,
Senior.
yes, I'll, you
Provide him a memo.
सत्यकाम करो.
We are all grateful.
You are for OERC or power district?
for OERC, my lords.
OERC, what is there to be contesting?
My lords,
And you want take instruction, you say adjudicatory body.
my lords, I have just received the file, my lords.
Sorry, you should not have made such statement. Your order, they are taking reference, they are taking help,
Yes,
and you say, I will take instruction. What instruction you will get?
my lords, I had asked for
You are appearing for Orida.
Orida, my lords, on the last occasion, in another case, Mr. Bijay Das had appeared.
They are
So,
We had soft copies.
If no appearance is there, it is to remain as it is. नहीं ये जो बीके नायक appear करथले तापर ଆଉ के आसीना नहीं एठी तो आउ की करिनाहंती जमा आपन संगे this Hon'Ble is there with you.
my lords, Mr. Ashutosh Das is there.
So आशुतोष ये सब
A Das.
right के नाहंती होला this company के नाहंती this item 6
Item 6.
My substitution petition is flag B also. Substitution petition, that is at flag B.
ये substitution allow करिबा is it not covered by our judgment?
Yes,
my lord. That is, I am appearing.
One order, your
Order is
Substitution
lordships,
टाको allow करो. Amended cost title filed. है substitution in the position of the petitioner. So that application is allowed. Filed in court. I would said the
yes, I have given two.
filed in court be kept on record. So tell in one sentence, is
One
it covered or not?
Yes, your lordship, in one matter remitted the matter back to the GRF, your lordship.
Both of you agree?
my lord, only may I submit one another judgment I have cited.
Why, what is that judgment?
That is on identical matter. This Hon'Ble court has decided it. Lordship can remand back because the
So
earlier.
remand as per this order.
Yes,
Then why are you confusing? two?
City side colleagues, it is equally binding.
I-
If it is
no,
binding on
my-
us, is binding on the GRF or the ombudsman.
My lord,
Then you may place this
Right.
in the remand proceeding. Why we will record?
I just bring the knowledge of the court.
No. The conclusion is different, Mr. Tripathi. What he is citing, that tango dekhichandi.
Hi. See you.
Any citation he wants to place, let him place without the.
remitted back is.
At the submission of the city council in petition involved following of the prayer. In the course of hearing, both parties agreed. Similar contentions being raised in WPC 14497 of 19. This matter has been allowed with an order of remand in the passing of the impugned order Ganesh 1 therein, finding the principle decided in the disposal of WPC 1447 of 19 applies also to this case. This court interfering in the order at Ganesh 1 herein also. Set aside the same, but as the requirement of press hearing of the proceeding involved, the matter is remitted back to GRF.
Miller, my.
You are the consumer.
I am for the OP2.
Okay, OP2 since already appeared and contesting here. Matter is remitted back with direction to both parties to appear before the GRF at least on 5th of June,
My.
5th of June, with their further contentions and citations, if any. Yes, with this observation, the revision stand disposed. Appearance का record कर लो आज ही record file को करे दो yes return कर दिया आपने
From 7.
right Guru.
Pardon me, Lord, I am in VC, Lord. Lord, this matter related regarding that claim of that remunerative benefit under Annexure 1, my Lord. Order of a GRF has been challenged.
7, my lord, I am appearing, and my information is that feeding processing unit has been closed since 4 years, my lord. If anything survive, then it will lordship can remand and the matter may be adjudicated if there isn't survive any cause of action, my lord. Because my information is that unit is closed
Unit is closed
since 4 years.
4 years. So what can be done here? What we will
The
gain?
order of a GRF under Annexure 1 is under challenge. Matter relating to the issue is, my lord, the remunerative benefit. My lord, the
That is the-
consumer has executed the work. After
Again.
getting an estimate.
Previous matter also this remunerative benefit, my lord.
Remand how you get into? So, I mean, we don't mind in remanding. But question is, since the company is closed for 4 years, who will be contesting there? So why are you pursuing such litigation? So find out execution or recovery of amount, if any. record the submission of Sri Falguni Raiguru Mahapatra. Upon copy appear
Consumer, my lord, opposite part number 2,
to the consumer.
my lord.
So if he is giving power to you, he is likely to contest.
My lord, but
So
the question
closure
is,
or non-closure, it is up to the closure, it can be decided.
here, my lord, the
Records that the consumer establishment involved in it. It's closed since last 4 years. This court expresses no opinion on the ultimate outcome. It will be dependent on the contest and period involved therein. Okay, to be likely to be asked and adjudicated by the GRF in the fresh consideration process. With this observation, the matter is remanded. Both parties are directed to appear before same date for the 5
5 obligement, because
So-
poultry farm is running. The feed processing unit, that is closed, man.
So you raise all these issues there.
My lord.
If you would not have appeared, then the things should have been otherwise. You are appearing, filing a vocalatna today.
Item 8,
Obliged. It is Siddha Suchini petitioner. Mahapatra to do P2. Yes, item 8.
May I please, Your Lordship? My lord, with due respect, my lord, I don't think
Yes,
this is
just
your
near
lordship's
mic,
assignment.
near mic. Mic agar tige ruhantu.
With due respect, my lord, I don't think this is your lordship's assignment, my lord.
Uh-huh.
This is not your lordship's assignment. Here we are challenging the order award passed by the industrial tribunal. The assignment is before Honorable Justice Arindam Sinha and S.K. Mishra, my lord. See point number 3 of that assignment.
Chief Chief ko ye achi ki nahi jodi amara assignment. Teta joda asuchi chief ko ye re asuchi. Etere kiye okilo kiye Durgananda is there, other side. So how raised to send this matter to him? Am pakhare 2-3 thara list hegalani.
Earlier, Mr. S.K. Mishra was appearing.
In
Earlier,
any-
Mr.
any stage-
Agrawal, Abhishek Agrawal.
No. To start with the litigation in 2021.
Mr. Nanda, you may clear this doubt. He was associated to Mr. Nanda's chamber.
My lord.
So has he ever involved in this?
No, your lordship.
You know, no assignment by Chief Justice this matter. We don't have assignment in industrial adjudication except special assignment.
My lord.
Counsel for the petitioner objects undertaking of hearing exercise by this court for no such assignment. This court peruse the assignment of this board, doesn't find such assignment. Rest it to find the assignment, place the matter accordingly. It be made clear there is no specific assignment by Honorable Chief Justice authorized also.
Obliged.
item 9,
May-
My lord,
Yes.
I am appearing for the NTPC. I am appearing for the NTPC.
Mic ta yade dhari sade pehle kaun?
I am appearing for the NTPC. The counter is ready, but due to illness of the officer concerned, could not be filed. Lordship, grant me 3-4 days so that we can
What you will be filing?
counter.
What counter affidavit?
Of-
What is
No,
this
but-
proceeding? What is this proceeding? This
My lord.
involve an award of the minimum wages authority.
My lord.
Then what counter you will be filing?
They are,
This is statutory proceeding.
they are disputing some.
No. It is, we will go by the records already there.
No.
No counter rejoinder is necessary. Yes, argue.
My lord.
Sao argue.
My lord. My lord.
They have filed a affidavit saying
Ignore
that.
that. Ignore that. He can't bring new materials other than materials available with the authority already considering the issue. Forget that.
My lord. My lord,
It's
and-
only, it's a statutory proceeding. Therefore, parties have to remain confined to the material already produced before the authority below.
And
And if anybody wants to file such document, then file with a memo. No affidavit is required.
then your lordship may take it tomorrow. my lord.
No, no,
Because
sorry. So,
today.
see, please don't play with the court.
No, my lord, because.
Your intention is to adjourn.
Your lordship may take it.
Then yes, you argue, Mr. Sahu.
Your lordship may take it
No,
tomorrow.
no, we'll take it now. Yes.
My lord,
Mr. Sahu,
the
argue.
impugned order is at page 23. My lord. The impugned starts from page 23, annexure 6.
Your workers,
My lord, where is the worker? We are 23 before lordship. My lord, may I place the impugned order, my lord?
annexure 6 is the impugned order.
My lord. My lord, 3 issues framed by the authority, that is as page 25. Whether the claim case entitled deserve,
Which page you are reading?
page 25, my lord,
25.
25.
Yes.
Well, 3 issues are there. The issue number 1, whether the claim case entitled deserved for condonation of delay by the authority. 2, whether the union is entitled to file claim case against the contractor under the statute. 3, whether the claim case is maintainable under scheduled employment, if yes, to what extent employee is entitled to get relief. My lord, so far the issue number 1 and 2 is concerned, 2 issues are in favor of the workmen. So far the issue number 3 is concerned, my lord. The learned authority said that this is beyond the work assigned, this is beyond the
Work
minimum.
mentioned in the schedule.
Madam, and
Beyond the work mentioned in the schedule.
they have said that this is not covered under the scheduled
Schedule.
employment.
So you have to satisfy first that the nature of work comes under the
Under
schedule.
the
of-
schedule. Well, this is the only question to be decided.
That is the only
My
question.
lord, I have, after filing of the writ petition, and I have filed a document of the central government notification, that is at flag B, my lord. My lord, may kindly see flag B.
How can we take that into account now?
My lord, what happened? A wrong notification was, the date is same, but the number of the
Mr. Sahu,
notification-
kindly answer the query of my lord.
My lord,
Can we
You may
take
be
such
wrong
a-
or right, that's not, we are not, which is wrong, which is right, we are not there. We are assessing or evaluating a judgment passed by a statutory authority.
Right.
So what was there before the authority and what was adduced on how, what he considered.
my lord.
Beyond that, we cannot say this is wrong, this is right.
Exactly, my lord. My
And
lord,
Mr. Sahu, keep one thing more in mind.
my lord.
Here it is negativing, finding that this doesn't come under the
The
schedule of
Schedule
employment.
of employment.
Now you have a material with you.
My lord,
So this is a technical rejection.
my lord, technical.
So why are you pursuing this?
My lord,
Why are you not going again before the authority? If you have a material to support you, this judgment will not come in your way.
my
Because
lord.
that judgment was never taken into account.
What my response submission before my lords is, the date of the notification is the same date, but the number is different. This is the case.
Sir, how does it help, sir? He doesn't
My lord-
refer to, kindly take page
An-
26.
annex-
Kindly page 26.
Yes, my lord. This-
Sir,
page-
just Mr. Sarkar tried to file an affidavit. We refuse that. We are not going, we have to go. So take page 26, paragraph 19.
Paragraph 19. Then
He refers to the, not only the number and the date, he also refers to watch and word has notified the schedule in employee.
And on that footing, he proceeds.
my lord,
It is not that he only referred to number and missed everything else.
my lord, they have in paragraph 19, the authority said yes or number 180 within bracket capital E dated 19.
Sir, don't read it again. Answer the query. It reads SO so and so dated 19/1/17, watch and word.
Watch and word.
So, and you claim to be watch and word person.
Watch and word.
So he has referred to watch and word.
Watch and word is within the notification number 191 within bracket capital E dated 19/1/2017 that I have annexed.
You
The
have
document
not
annexes-
annexed that, you have not annexed before the authority.
Authority, it was not.
So what can be done now?
Then can the read court in a writ of certiorari entertain such issue. We have been hinting on other thing. You are not taking that into account.
My lord,
This is technically taking away your rights.
my lord. Therefore,
So why are you pursuing this?
may I pray, my lords may remind the matter?
No, there is no question of remand. You are not understanding.
Because I understand, my lord.
You understand, then make the clear prayer.
My lord, clear, my lord, the technicality.
Mr.
is-
Sahu,
My lord,
then we proceed for order. Material produced here were not considered, not produced, nor considered. Statutory court has no jurisdiction to enter into such issue. That's the order only. So take that order to find out. There is no question of remand. Because a material produced here which has not seen the light of the day at the time of consideration.
with that observation, my lords may dispose of, let the authority may reconsider the matter.
You are not asking for liberty.
It should be dismissed, sir. It should be dismissed.
ଆପଣ
ଆପଣ
ତାକୁ
ଯୋଉଟା
ପାଠ କରନ୍ତୁ, ଆପଣଙ୍କର
ଆପଣ
ଅଛି।
ଫାଇଲ କରିଛନ୍ତି ରିଟ୍ ରେ ଯୋଉଟା ଫାଇଲ କରିଛନ୍ତି କୋଉଟା ଫାଇଲ କରିଛନ୍ତି ଫର ୟୋର ସାଟିସ୍ଫାକ୍ସନ ନୋଟ୍ସ ଆପଣ ଦେଖନ୍ତୁ ସେଇଟା we can go through that
ମୁଁ annexure 7 ଟା file
Seven?
କରିଛି affidavit ରେ।
ଦେଖନ୍ତୁ
ପେଜ ଦେଖନ୍ତୁ।
ଦେଖନ୍ତୁ କଣ ସେଥିରେ ଅଛି
ପେଜ କେତେ?
Well, annexure 7 to the, that is, my lord, at flag B, my lord,
ପେଜ କେତେ କୁହ?
page 3, my lord, internal page
Sir,
3, annexure 7.
flag B ରେ ଯାଇକି ଅଛି
ଫ୍ଲାଗ ବି ରେ ମିସକେସ ରେ ଆଣିଛନ୍ତି ଆଫିଡେଭିଟ।
Affidavit.
So annexure 7 flag B ରେ ଆଣୁଛନ୍ତି।
ଆଜ୍ଞା। Notification SO 191 capital E, New Delhi, the 19th January.
Was this available for the authority to consider?
Well,
Then how we come
ଆପଣ
to?
you are arguing against your case or in favor of your case they say that you do not come as in the notification for watch and ward.
Well,
This specifies the minimum wages for watch and ward.
well, lord.
So how does it help you that a wrong notification was taken into consideration?
This notification.
Suppose a notification number XYZ say that notifies what is watch and ward, but he has taken the notification refer to the schedule.
A wrong.
Kindly read the notification what you have filed at flag B.
My
Just
lord.
read that.
My lord,
How does it help you?
my lord, my lords may kindly come to 4th paragraph. Now,
So start reading from the first line. Straight away, if you go to 4th paragraph, you will be on the way. You are lost everything.
whereas the draft,
Read slowly, and so that you realize what is there. That
my lord, whereas the draft proposal to revise minimum rates of wages per day payable to the categories of employees mentioned in schedule annexed thereto and engaged in the employment of watch and ward was published in the Gazette of India Extraordinary Part 2, Section 3, Subsection 2, by notification of the Government of India and the Ministry of Labor and Employment, number SO 2837E, dated 1st September 2016, as required by Clause B of Section 1 of Section 5
just
of the Minimum Wages
don't read the entire thing. Just go to the last 4th subpara.
Fourth,
After consulting the advisory board, hereby revise the minimum rate of wages payable to the employees engaged in the employment of watch and ward.
my lord,
So,
payable to the employees engaged in the
and now you
employment of watch and ward.
again go back to that paragraph 19. Was it referring to the rate of wage or it was referring to the category of employment? Then you will realize that it doesn't help you.
But this will be helpful, my lord. Watch and ward,
Sir, they are also not, they will not dispute that it is a revision of wages. Then now you take page 26, paragraph 19.
paragraph 19 is a different notification, my lord.
Sir, obviously it is different, but read that, it is different. Kindly, then you will understand that that notification is not relating to the schedule. That is regarding enhancement of wages, minimum wages.
My lord,
So why you are shying away from reading paragraph 19?
no, I'm.
So the read it. That was not an issue there.
The central government by notification number 188 packet E dated 19/1/2017, watch and ward has notified in this schedule employment.
Then
It
you
is
read
there.
the 20, 21, 22, then you realize, especially 22.
Well,
During the interrogation, the contractor admitted that they have not obtained any license under section 4 of the said act. They have obtained license from Ministry of Labor and Employment for providing unskilled worker for track maintenance job.
So watch and word.
The principal employer has submitted the watch and word in their establishment are provided by professional agencies like CISF and DGR sponsored.
So
Director General sponsored agent. When I am reading, you have to look there. By looking at my face, you will not get it. Because I am reading your brief.
Well, I am placing the annexures.
In this regard, the worker themselves admitted that they are not imparted any training as security guard by employment, or they belong to Army, Navy, Air Force, or any other armed forces of the Union Police, including armed constables of state or home guards as per the section 10(3) of the said act.
So neither this notification nor that notification comes to your rescue. You have to first establish that you are holding a post of watch and ward. Otherwise, none of these notification come to your rescue.
My lord, that is the
So
agreement.
therefore, now that has become a disputed question of fact. You have admitted yourself, you are never employed in watch and ward.
That, no, my lord, this is not the case. Well, there was an agreement between NTPC and the contractor. Well, that in opinion number 2 in their counter have filed the copy of the agreement. Your lordship, I am taking.
Why did you admit then?
My
Why
lord,
did you admit that you were not in watch
my
and
lords
ward?
may kindly come to their agreement, my lord, at annexure B to the counter filed by the opinion number.
Your admission marks your case. Why should you go to other things? Your admission, please read para 22 again. You have admitted, yes, we are not imparted any training, nor we are ever employed in watch and ward. Your employer also denying, say, no, they are not engaged, and rather they say these are professional agencies, experienced.
My lord, what is our assignment? What is the work, the work order issued by the NTPC in favor of the contractor?
Then that is none of the issue of the minimum wages authority.
My lord, that your lordship may kindly come to the agreement. Agreement is very clear, watch and what.
Then why you
And our
admitted?
view, my lord,
Why you admitted 22? If 22
well, 22,
is,
my lord, I am placing, my lord, 22 at page 26.
yes,
During the interrogations, the contractor admitted that
yes,
they have not obtained any license under section 4 of the said act.
right. Unless a license is there, you can't
But that, but
work in
my
this
lord,
side.
this is this between the,
Read further also.
my lord, during the interrogations, the contractor admitted that they have not obtained any license under section 4 of the said act.
Yes.
They have obtained license for Ministry of Labor and Employment for providing unskilled workers for track maintenance job.
For track maintenance, you are all track maintenance.
Now, my lord, the track maintenance is watch and ward. That I,
Oh, that is, therefore we say that is none of the issue with the minimum wages.
Well-
Your door is somewhere else. You have to first establish that your work is of a watch and ward.
my lord,
Then only you come under the notification.
my lord, that,
Now minimum wages authority do not have such power
well,
to
my lord,
find whether one is doing watch and ward or doing the other type of job.
my lord, the watch and ward is our duty because the maintenance work is watch and ward.
No, that you say.
No, my lord, this is their agreement says. The agreement between.
Kindly read 20.
My lord,
Read paragraph 20, just above 22. Start reading.
my lord,
Maybe you are not the conducting counsel there. You can't improve the case, whatever happened. So you
my lord.
you try your best even. 20 পর্যন্ত।
Yeah. The union has submitted that the authority has decided a case in favor of applicant, that is LEO Central, but employer has not adhered the directions thereafter. In this contest, I am of the opinion that all the cases are different to each other based on supporting documents and evidence. Where LEO Central has submitted copy of wage register in which it is clearly designated as security guard. However, the applicant union has failed to submit any documentary proof on the above issue. Rather, they have enclosed copy of the identity card of one workman of a Messer Shakti Security Agency, which has got no relation with the employer. Further claim case is filed for 32 number of workers. Both the claim statement and documents are contradictory to each other, as in claim application only 29 number of workers are signed authorizing the union to represent the case. When the authority has stated this because in similar cases, LUS Central has extended the benefit of minimum wages to some workers. There we have placed.
Read further. Actually,
Page
between
21.
instead of reading, you are going on read 21. That is
Right,
again
right.
crucial.
Further, the employer as well as the contractor has submitted that as per Private Security Agencies Regulation Act 2005, number 29/2005 dated 23rd June 2005 under section 4, no person shall carry on or commence the business of private security agency unless he holds a license issued under this act. Under section 9(2), every private security agency shall ensure imparting of such training as skills to its private security guards and supervisors as may be prescribed, provided that the persons carrying on the business of private security agency before commencement of this act shall ensure the required training to its security guards and supervisors within a period of 1 year from the date of such commencement. My case is not coming under that the Private Security Agency Regulation Act. There was a tender. The tender
Mr. Sahu,
by the
there is a express prohibition. After 23rd June 2005, you cannot do this because again, if you are doing this, then that is illegal.
There
my
must be
my
license.
response
License.
commission before my lords is there was a tender issued by the NTPC.
Mr. Sahu, sorry. Mr. Sahu, sorry, your door is somewhere else.
My lord,
At the submission of Sri Sahu, Learned Counsel and Sri Sarkar appearing for the.
OP number 3. OP number 2. I am OP number 2.
You are Union of India,
No, 2, your lordship, contractor.
contractor.
may I
D.K.
permitted,
Mahanti.
when
D.K. Mahanti.
Yes,
may I permitted to
Mahanti.
place the agreement will not filed by Mr. Mohanty?
Pardon?
OP North, to place the agreement between the NTPC and the
No,
contractor?
not necessary. That was not taken into account by the
But
lower
that-
authority, therefore we will not consider.
Well, that there is
Sorry,
the
sir.
condition.
Sir, we have given you a lot of liberty.
Well, lord,
This is not a case at all before the minimum wages authority. Your contractor is opposing your claim.
when the contractor is opposing, my lord.
That's right.
My-
Therefore, then your case is gone. Then ଆମେ ଏଠି ପରାମର୍ଶ ଦବାକୁ ବସିନୁ dilemma. Minimum wages authority cannot take a decision here. They have no authority to find out. Sorry, you take advice of proper counsel. What should be the road for you? In the course of submission, this court observe through para 1, the claim of the petitioner, the workers involved therein, also involved herein, through para 4, clear denial by the contractor on the type of engagement claimed by the worker being watch and ward. Further through para 19, 20, 21, 22, there has been thread-bread discussion on the claim of different parties involved, bringing in clear material in the claim of the, opposing the claim of the workers involved herein, engaged in watch and ward so that their case may be covered under the scheduled employment. In the revision wage notification, it is at this stage of the matter finding no scope in contesting matter before the minimum wages authority under the Minimum Wages Act. Sri Sahu Learned Counsel seeks withdrawal of the writ application to bring appropriate proceeding before competent authority. The proceeding permitted to be done, however, with liberty. Time limit, you have not yet visited the establishment or the adjudicator as of now, ame time limit kon karibu? You now advise how early he can go to the authority and which authority and in what form.
That is the doubt, ma'am.
Advice. No, criminal appeal uda to. ନା ଏଗୁଡାକ ଛୁଟି ପରେ ଗୋଟେ week ରେ ଗୋଟେ date କରିବୁ ଗୋଟେ କରିବୁ working week ରେ ପ୍ରତି week ରେ ଗୋଟେ ଦବ ଏଇ 16 ଟା ରହିବ list साधु महांती
प्रभु प्रसन्न बेहरा
प्रभु
प्रसन्न बेहरा
Mainly the authority.
पीपी बेहरा
ହେଲା महांती करो OP1
यस मैम
OP1
Mainly the appropriate authority, I will find out, my lords, may fix time limit.
now we are not there
My lords, may I pardon to make a mention, my lords. Item 12, my lords, the same list will be taken up tomorrow.
ଆସିବ ବାକି ତ କେସ୍ କାଲି
But tomorrow I will not be there, my lords. That's why I made a mention, my lords.
12 କେବେର matter
Day after tomorrow is okay, my lords. Item 12, my lords.
ଠିକ ଅଛି ଛୁଟି you are for
I'm for opposite partner
you
2,
are
my
for
lords.
OP
Points.
number 2
Yes, my lords.
Item
Alright.
10 Miller.
after vacation 10 କଣ ହେଲା
Next item Miller 10.
आइटम 10 my lord.
This Miller settled. Already
No, no,
settled.
I-
There is nothing survives
Because
as
there-
per the.
The matter is already been settled. I have to not to press the memo file.
memo ଦେଇ ଦିଅନ୍ତୁ yes
You lords may observe.
council
Milord, in item 10, Milord, only after my consent is obtained, Milord. Milord, my consent has not yet been obtained, Milord. I am to return the file, Milord. Milord, without consent, Milord, how my lord and friend is, Milord.
bar council move କରିବେ କୁଆଡେ move କରିବେ ଦେଖନ୍ତୁ ଏଠି ଆଉ କହିଲେ ଆମେ କଣ
Lordship,
You have no right to come at this stage.
This memo has been filed at the instance of the petitioner, council, by the council for petitioner indicating there has been outside court settlement. In this circumstance, memo be kept on record in this circumstance, this court find nothing more to be adjudicated. Proceeding dropped. Keeping in view there is outside court settlement.
My lords,
Lordship,
item
You lords may
15, my
record
lords.
on instruction from the executive engineer. I am submit.
Okay, Mr. Mishra supports the submission of Sri Falguni Rajguru Mahapatra on instruction.
On instruction.
I am
Yes.
for OP number 1, your lordships.
OP1 पे Mr. Das का नाम लिखी दो
Great for that.
Lordship, item 15, my lord.
Abhishek Das.
My lords, my
Abhishek
item-
Das with you or he is
No, for
independent?
the commission, my lord.
Milord,
You are for
Milord, my
OP1.
appearance is there,
OP1.
You are for
Milord, TPCODL.
Milord, TPCODL, I am appearing. My appearance has not yet been
Lordship,
withdrawn,
item
Milord.
15,
My
my lord, may permitted to withdraw.
Item?
Item 15, my lord, with liberty
15.
to pursue appropriate remedy. at
file,
the-
you are filing memo?
Memo file.
Okay, memo is filed for seeking withdrawal of the writ application.
My lord,
This dismiss as withdrawn. Rai को नाम लिखी
With
दो.
liberty, my lord, to.
my lords, my
Deeply
item is,
oppressed.
my item 13, my lords.
13 अर्जन ହେଲା परा?
That is 13, my lord, not 12. So yesterday it was 12, my
Oh,
lords.
सेटा 13.
Yes, my lords.
Okay, okay, sorry, 12 no 13. 12
Like-
काली के आसिबो.
Deeply obliged.
12 काली के आसिबो.
12 is my lord.
आ बाकी जहाँ रोहिला काली के आसिबो जोड़ा का.
Item number 14. Milord, item number 14.
See 14 କହୁଛନ୍ତି.
15.
Milord, item number 14.
14 ଅଛି କାଲି के आसिबो परा? Tomorrow.
Can you hear us? Tomorrow, lordship is saying tomorrow.
Very well, Milord. Grateful.
One.
None appears for the person. However, considering the Innoco's request in the disposal of written application, this court observed,
My lord,
provided there is service involving SRP 70 of 19 is completed. Lawful disposal be brought involving SRP 70 of 2019, at least within a period of 4 months from the date of communication of order.
Item number 2.
may I please ask? My lord, impugned order is at annexure 7 and 8, my lord. The order passed by the collector in an mutation appeal filed by the additional Tahsildar, my lord, by the annexure 6, my lord. My lord, on the basis of an order passed by the annexure 3, the joint
You
commissioner,
are
my
the mutation applicant.
my lord.
You are the mutation applicant.
My lord, I am the applicant. I am the applicant.
You are the mutation applicant.
Yes, my lord, I am the mutation applicant.
Yes, so what happened to mutation proceeding?
Mutation was allowed in my favor, my lord. But
Annexure 7,
annexure 4, my lord.
annexure 4.
My lord. Yeah, my lord.
Page.
Annexure 4 at page 26, my lord. And on the basis of the mutation, ROR also, my lord, published in my name by the annexure 5, my lord.
Okay, annexure 4 was allowed in your favor.
My lord. Thereafter, my lord, ROR was published, my lord, in my favor, my lord.
ROR has been published.
Then, my lord, additional Tahsildar, my lord, preferred an appeal. Your lord, see, kindly say, my lord, annexure 6, my lord,
Additional
at page
Tahsildar
32. On 1/11/2022, my lord.
passed the order to annexure 4.
Annexure 4, my lord, it's the mutation appeal, my lord, preferred by the additional Tahsildar before the sub collector, my lord.
Annexure 4.
My lord, annexure 4 is the, my lord, Tahsildar passed the order, my lord.
Tahsildar passed
My
the
lord.
order. That is page 26.
Page, my lord, annexure 4 is at page 26, my lord.
Page 26 is part of annexure 4.
Yes, my lord.
Annexure 4, you have filed 2 documents.
Annexure 4 starts with, my lord, at page 26, my lord. The relevant page is, my lord, the relevant page is, my lord, page 29, my lord.
Then what is annexure 3?
Annexure 3, my lord, an order passed by the Joint Commissioner Settlement and Consultation, Sambalpur, my lord, in an application filed by the present petitioner, my lord, in a revision case number
It was allowed
400.
in your favor.
It was passed in my favor, my lord.
So the mutation application was dependent on this order.
Yes, my lord.
Okay, so mutation was consequently allowed.
Mutation was subsequently allowed, my lord.
Okay, then who preferred appeal?
My lord, additional Tahsildar preferred an appeal, my lord.
Oh, not the Tahsildar.
Not the Tahsildar, my lord.
Okay, then how are you agreed by it?
My lord, additional Tahsildar preferred an appeal on, your lord, see, kindly see, my lord, page 32. It was on.
Annexure 6 is the appeal.
Yes, my lord. It was filed on 1st November 2022, my lord.
Yes.
With a limitation, my lord, with a prayer, my lord, on the last line at page 33, my lord.
Yes.
Further, it is prayed that the delay continuation may kindly be allowed under Rule 5 of the Limitation Act, my lord.
This involved the mutation order.
My lord, my lord, the
mutation order was dated 5/1/22.
Mutation order was on 5/1/22, my lord.
And appeal was filed on?
Appeal was filed on 1/11/2022, my lord.
1/11/22. So therefore, there was some delay.
My lord. My lord, on the same day, my lord, on 1/11/2022, my lord.
Oh, yes, what is this? You have not been noticed then.
Not noticed on the same day, my lord. The order was passed by this.
And appeal will be considered on its own merit after considering the condonation
Yes,
delay. At the submission of the Naik Learned Counsel for the petitioner and the Ponda Learned AG for the state contesting opposite party. Taking this court to the development through annexure 3 in allaying of 37(1) of also OCH and PFL Act proceeding. Petitioner appears to have brought a mutation proceeding registered as mutation case 17 of 2014, allowed by the Tahsildar Latikota by this order dated 5/1/22, bringing to the notice of the court the appeal preferred by the additional Tahsildar by annexure 6 on 1/11/22. taking this court to further the plea on condonation of delay by the additional Tahsildar, the appellant therein. It is at this stage further taking this court to the order of the appellate authority. Annexure 7. What is annexure 8?
Annexure 8, my lord, the order was, my lord, passed directing the Tahsildar, my lord, by setting aside the earlier order of the Tahsildar, my lord, for a fresh disposal, my lord. Annexure 8, my lord, again the order of the Tahsildar reversing the mutation, my lord, passed in my favor, my lord.
Now, how annexure 8 came into picture again?
My lord, your lordship kindly see, my lord, annexure 7, the order, my lord.
Annexure 7, the appeal was allowed.
Appeal was allowed, my lord.
Okay.
In the appeal, my lord, it
Ah.
has a direction, my lord, at page 37, my lord.
Oh, by setting aside, he remitted the
Yes,
matter.
my lord.
Now the Tahsildar is passing fresh order.
Fresh order.
Okay, it will go back to that stage with taking away both the orders. Okay, reading together with 111 order of the appellate authority in revenue appeal 74 of appeal number kete hai?
My lord, appeal number
74 of 22. Yes, 74 of 22.
yes, my lord.
The Nayak alleges, first of all, since there was delay condonation aspect involved, notice would have been issued to the party likely to be aggrieved, the petitioner.
And the order was passed on the same day, my lord, on 111.
I'm taking, why are you hurrying?
Sorry.
Secondly, there is serious allegation that the appeal by Annexure 7 came to be allowed on the date of filing of the appeal on 1/11/22 itself. Okay, considering strong ground in the challenge of the appeal orders, this could also involve the submission of Sri Panda who submits, or there is threadbare discussion in the appeal. And further, there is remand of the proceeding to the mutation authority, the order should not be interfered with. There is however no objection to the claim of the petitioner herein on. No independent decision on the limitation aspect. Further, the appeal involved herein was decided on the date of filing of the appeal and in absence of involvement of the party likely to be affected. Okay, in the above circumstance, this court find there is strong case in favor of the petitioner, as the appeal RA 74/22 was brought on 1/11/22 and the appeal also disposed of with a remand order, though with a remand order on 1/11/22 without involvement, not only without involvement of the petitioner, but in no decision in the involvement of the petitioner on also on limitation. Okay, it is accordingly this court find the order at Annexure 7 not sustainable in the eye of law. As a consequence, the subsequent order of the Tahsildar Annexure 8 also remain unsustainable. Okay, in the process, this court setting aside order, both the orders at Annexure 7 and 8 allows the writ application and relegate the matter back to the appellate authority, deciding RA 74/22 for involving the petitioner's objection on the question of limitation, to decide on the question of limitation first, and if necessary, and the appeal survives, to proceed to decide on hearing of in the appeal. This court direct the petitioner for remand of the proceeding. This court direct the petitioner to appear before the appellate authority on 30th of May, along with its objection to delay condonation, if any.
Item 3. Item 1 lordship
Pardon?
Item one, Lordship, I was not. there.
Item 1 କୁଆଡେ ଥିଲେ ଆପଣ?
6 number court.
ମୁଁ ତ 5 ମିନିଟ ଡେରିରେ ଆସିଲି ଆପଣମାନେ ଆସିବା କଥା ନହେଲେ ଆପିଅସ କାଟିଦିଏ.
Let's go.
Yes, next.
Item 3.
My lord, 3, I have filed the affidavit along with the order sheet of election petitioner 2 and 3, my lord. With the Bhaklatam and the receipt. Perhaps that has not come on record, my lord.
ମାନେ ଆସିଛି.
Yesterday, ଆସିଛି.
ଆପଣଙ୍କ ଭୋକାଲାତ ଆସିଛି.
Bhaklatam ସହିତ ସବୁ affidavit ସହିତ Bhaklatam ଦେଇଛି.
ଠିକ ଅଛି. You are appearing for the contesting opposite.
Yes, yes. My lord, what happened?
Lordship,
ଆଗେ ରୁହନ୍ତୁ ପିଟିସନ
Pardon?
ଶୁଣି ସାରେ.
Lordship, kindly.
ଆପଣ ଅପୋଜିଟ ପାର୍ଟି ଆର୍ଗୁମେଣ୍ଟ କରିଗଲେଣି.
ନାଇଁ କରିବା ପାଇଁ ନାହିଁ ମୁଁ affidavit କହିଥିଲେ ଯେ ମତେ order sheet Bhaklatam ଦବା ପାଇଁ ସେଥିପାଇଁ
ଆସିଯାଇଛି ଆଜି ପରା.
ହଁ ଆସିଯାଇଛି ତ.
Lordship, kindly pass over the matter.
ପାସ ଓଭର ହେଲେ ଆଫ୍ଟର ଭେକେସନ ଯିବ ଆଉ ଆଜି ହେଇପାରିବ.
Lordship, kindly one pass over. Lordship.
Tomorrow.
Oblige, Lordship.
Yes. On the request of learned counsel for petitioner.
Item 4.
Provided there is pleading complete. SRP 234 of 19 is directed to be concluded within 4 months.
Item 5.
May I please your lordship, I am appearing through virtual court.
Yes, Mr. Padjusi, कौन है case?
Your lordship, this is an application for the direction to the opposite party to disburse my legitimate pay that the petitioner is entitled to for his work, that is construction of CDPTF at Dukermal under Karlamunda JP in the district of Kalahandi. Your lordship, my representation annexed 7 is pending now. But before that, your lordship, may kindly see annexure 5, page number 21.
Yes, there was earlier petition.
Yes, after completion of my work, a person namely Aurobindo Chaudhary had filed one writ application before this honorable court, challenging the allocation of land by the Tahsildar, wherein your lordship in division bench with the honorable ex-chief justice.
We had directed the collector to pass a speaking order.
Yes, your lordship. The annexure 6 RTI application, the recent RTI application, it has been more than 2 years. The collector has not yet complied the order passed in WPC 27380 by the
Let us direct the principal secretary to take a decision.
Yes.
It is pending. Take a lawful decision on that. Also, keeping in view the judgment order of this court on earlier occasion.
And let my representation be also disposed of, your lordship.
This petition had Sri Padjusi, learned counsel appearing through VC. Undisputedly on the self-same issue, petitioner has a pending representation with the opposite party number 1 by annexure 7. The Padjusi in the course of hearing taking this court to annexure 5, development through annexure 5. In the previous round of litigation, claims in spite of direction therein, the matter, the authority is still sitting over the matter. Okay, be that as it may, for pendency, keeping in view pendency of a representation of the petitioner at annexure 7, matter stand disposed directly OP1 to take a lawful decision on the request of the petitioner by annexure 7 by, if necessary, in the involvement of the petitioner and by completing, giving a lawful outcome at least within a period of 2 months from the date of communication of order.
Much obliged, your lordship.
Item 6.
5 to 10.
Same.
Your lordship, 6 to 10 is same.
Okay, all right.
5 to 10.
All involved repetition here earlier.
Yes, your lordship.
Okay, all right.
Item 11.
Just one minute. Mr. Padjoshi, city temperature kete?
Item 11, my lord had directed us to examine whether the judgment rendered by my lord will be covering these cases, my lord. My lord, here it appears, my lord, there is some difference. So far the ratio is concerned, there is no, my lord, dispute. That is the settled law. What has happened, my lord, here the rendees are before your lordship, The vendees are before your lordship, and their vendor was originally a Lord Jawan leaseholder. Now, my lord, what has happened in course of the proceeding, my lord, before the both the lower court below, my lord, your lordship will find page 47.
Yes.
Despite repeated notices, sorry. Yes, 47.
To file objection, file objection. But.
No, objection to Mrs. Black sessionary proceeding. Objection to Hoboni, take a factually, I was just talking to my London friend. He has referred to an order passed by the Tahsildar wherein, my lord, the proceedings were resumption proceedings were dropped. There, the
Same case, earlier case also, same situation.
ନାଇଁ ଠିକ ଅଛି ସେମାନେ ଦେଖେଇ ପାଇଲେନି ଲିଜ ଏଗ୍ରିମେଣ୍ଟ ଟା ବୋଲି ସେ କହୁଛନ୍ତି ଯେ what are the conditions of this?
That was what I have decided in this case probably.
Yes, ଏଇ case
You can't ask for document. It is your document.
then you also can dispose of it.
So these are similar cases.
ମୁଁ ସେ କଥା ଟିକେ ଡିସ୍କସନ କରୁଥିଲି ଯେତେବେଳେ ମୁଁ ପଚାରିଲି I found out the judgment of this court ଯେ grants act ରେ ଯୋଉଟା ଲିଜ ହେଇଥିବ ସେଟା ଆସିବନି.
Manoj Mishra was
Yes, that is the judgment. My London friend has provided that.
Care Mahapatra judgment.
ଆଜ୍ଞା ସେଥିରେ ଆହୁରି କ୍ଲାରିଟି ଥିଲା କାହିଁକି ସେଇ
ସେଥିରେ no Manoj Mishraଙ୍କର case ବରଂ better case.
ସେଇ କଥାରେ କହୁଛି.
Most cases were allowed earlier by this bench. Holding that there is transfer by this Jawan lease holder. So and that was a transfer. Then subsequent record of rights were also prepared in their favor, but it was taken away subsequently.
ୟାଙ୍କ କେସରେ ହେଇନି, ୟାଙ୍କ କେସରେ ଜମାରୁ ପ୍ରିପେୟାର ହେଇନାହିଁ.
ଯଦି ହେଇନି ତାହେଲେ କରିବେ ଆପଣ.
ଆଜ୍ଞା. On this ratio, on the basis of this ratio. And second କଥା ହେଲା ସେଟା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଖାତାରେ ଉଠି ଯାଇଛି ସେଟା. ରେକର୍ଡ ହେଇଛି.
ଖାତା ଗଲା କେମିତି? Government khata gala kimti. That is the crux decided here.
Vendors are not coming. Sorry, the vendors are not coming forward.
Why should they come? See, tangaro biki dele. See, biki dele.
That is the reason why probably they asked that if there was an alienable right.
Sorry, darkan. Registration he jaichi document.
Agya, registration he jaichi.
The land was upon gotti instruction khali mata kuhantu.
Agya.
Land was earlier given to the Jawan or not.
Yes. Yes, yes.
So it is once it is given to the Jawan, it cannot come back to the state.
Yes. Under the Grants Act, particularly.
Under the Grants Act.
Your lordship may pass that on.
Annexure 4 and 5, your lordship, that was the mutation case and the conversion case. Both are allowed, and I paid the premium.
Okay.
But
you being the subsequent purchaser.
Yes, my lord. I am the first purchaser from the legal heirs of lessee.
All these petitions are purchased from the legal heirs of the lessee.
So now what is the order you are challenging?
That is the order, your lordship.
That I was referring to, my lord. Page 47.
Taking back the land to the government.
Yes, my lord.
Rejecting their claim for, my lord, because earlier there was a direction by this honorable court that there is a appeal provision.
All right. Justice Mahapatra.
Yes.
Same case. Requisition involved the following prayer. Considering the case in similar situation, there has been disposal of a number of interceptions holding there is no scope at all in reversion of the Jawan lease land. And thereby holding the decision of competent authority in the reversion of the land to government becomes bad. Decision decided, a decision of this judgment of this court in more judgment ta kahin? More judgment ta diyo. Chief Justice ka judgment kahin dekhauchandi? See, that is a different case.
Yes, madam.
Thoda kahin it dekhauchandi?
Sorry, madam.
Yes. One such case, the case is here is squarely covered by WPC 22872 of 22. 22872 of 22 decided on 20th 4/23. This court accordingly on whole application of the judgment indicated here in above. Finds the impugned order here, Anisha.
12, my lord, and also 10.
10 and 12.
10 quota, consequential quota.
12,
12 is consequential.
my lord.
10 is passed by the ASO, 12 is the consequential.
Right.
Appeal, in appeal.
So 10. Find the annexure 10 remains unsustainable. As a consequence, annexure 12 also remain unsustainable. In the process, this court. Appeal টা reject করে দিয়েছেন allowing the appeal case number দবা in setting aside of the order at annexure 10 and 12 respectively.
No, appeal has been disallowed also. Appeal the same order confirm ହେଇଛି. First hala annexure 10.
That is to be set aside.
Yes.
That is to be set aside. So, yes, while allowing the appeal, in setting aside of the order at annexure 10 and 12, direct the Assistant Settlement Officer Bhubaneswar, opposite party number 3 to bring corrections in the record of right in respect of the petitioner and involving the land involved in the sale deed. The entire action be completed. The entire action in bringing a new record of right in favor of the petitioner be brought at least within a period of 2 months of the production of copy of this order.
I would technically add by involving the Tahsildar, because by involving the ASO will do well by involving the Tahsildar.
Okay, yes, ASO in the involvement of the Tahsildar.
Kahin se Sekhar direction he is the custodian of map, record of right.
Okay, okay. Yes, next.
Item 12. Same matter, my lord.
Same. এটারে annexure কেতে কেতে হবো?
এটারে annexure say 10 and 12.
Say 10, 12.
My lord.
তারপর আউ দুইটা আছে।
Okay.
15 ଆଉ 16.
15, 16 ବି ସେ আছে। Right. ଆପଣ ଗୋଟେ ସ୍ଲିପ ରେ ଲେଖିକି ଦେଇ ଦିଅନ୍ତୁ ହେଲା ଏ କେସରେ ଏଇ annexure and ଏଇ appeal number
ଆଜ୍ଞା
ହେଲା and the extent of land as per this so 12 ବି ଗଲା yes
14 ରହିବ 15 16
13 ରୁ after recess କରିବା Mr. Pal after recess
15 16 ଦିଟା ବାହାରି
15 16 ଦେଇ ଦବା
87
Yes,
may I please? This is that same say, passport for they refuse they on the basis of that criminal cases are pending. I again am allowed by annexure 2 series. I have made a representation along with all the judgments of your lordships, everything, and also with an undertaking which requires that the notification requires that I should file an undertaking. I have given the undertaking also. Lordship may see that undertaking at page 44.
What happened ultimately?
Nothing has happened till date, but till today I received a communication that they have called me to on 5th June with all the documents.
Then
let me, my lord, I only say that Lordship may say that I will appear on 5th June with all the documents and all the required.
Therefore, this is a pending proceeding. Why you pursue such litigation here? Then now they may say the case is pending. What should we do?
No. They first, my lord,
that is subsequent development.
Yes, that is subsequent development.
Now that you have got with that, you will withdraw this writ application. If necessary, you will pursue again.
Initially, she was invited on page 19 on.
Pardon?
March. Initially, she was invited on 7/3/2020.
Pardon, asuni, voice asuni.
Initially, she was invited on 7. My lord.
Yes.
Initially, she was invited on 7/3/2023. Thereafter, what correspondence, my lord?
Right. Now that a communication is made, you go and attend their office.
Only your lordship may say that I'll attend that will the all document, let them consider. That is all your lordship may dispose of. With that observation, your lordship may because this letter I have got not legible.
In the course of submission, further communication to the petitioner has
Okay,
been
court.
produced in court.
ठीक है,
And
legible
it
लोग
has
से ना computer
It has been brought through the communication dated 6th May 2023. The petitioner has been called upon by the regional passport officer.
Only problem the subject mentioned is, and that is why it is
Right.
subject says that it file closure alert. That is why I am bit apprehensive.
So they indicate there you have not submitted the required supporting documents as asked during your visit to PSK Bhubaneswar on 7th March 23.
I have all documents I have filed. Anyway, I'll support whatever your lordship has directed in that writ application.
Party, however, submits. Therefore, there is further communication to the petitioner. Nothing prevent the petitioner to appear before the competent authority on the
5th.
Now this date has already expired.
No, 5th June. 5th June they have said.
5th June. Okay.
5th June.
On 5th.
Last paragraph, appointment before honor before 5th.
Okay, honor before 5th June 2023. With required document as per instruction 7th March 2023. The Paliya submits for there is further scope for satisfaction of the petitioner's case. He doesn't want to proceed with the writ application, but the petitioner will now attend the office of the regional passport authority with the desired document. Okay, on the petitioner attending the office of the regional passport authority, the regional passport authority is directed to take a lawful decision on the application of the petitioner, while also keeping in view the judgment of this court in WPC 4834 of 2022. Yes, with this observation, the petition stand is both.
Personally reflect along with
Yes,
me.
Item 14.
Obligement.
Along with Mr. Kashyap is appearing. SS Kashyap.
Kashyap ka naam hai. Yes.
Item 14, on the last occasion, your lordship had directed to obtain instruction. This is that construction of that pond, my lord, illegal construction. Your lordship had directed on.
Yes, any instruction?
Lordship, we have received the instruction. I'm serving a copy.
Favoring or disfavoring?
Lords, in fact, the instruction that the BDO opposite party number 2 has sent is that both the BDO and the junior engineer, both of them were completely unaware of this construction that is going on, your lordship. Lordship, may kindly see annexure 1 to that instruction. Para C.
Yes.
That no layout was provided by the concerned junior engineer on the prescribed site to proceed with the aforementioned project, nor has the junior engineer concerned been involved in the supervision or monitoring of the work.
The digging is illegal now.
Lordship, from the instruction
let me
it
issue
seems.
notice with a stay order.
Lordship.
And you bring this on record.
My lords.
Had the submission of the learned counsel's father. In the course of further submission, it has been brought to the notice of the court. The instruction submitted to Sri Sonok Mishra, learned ASC, and paragraph C of the Parvai's comment clearly discloses there is no authority, there is no layout even in the digging of the pond. This court find let the state brings appropriate counter affidavit in terms of instruction herein. Issue notice. Requisites accordingly. Miscase. Let there be miscase be notice karta. Let there be status quo in respect of the property schedule court achi.
But if your lordship sees the schedule confining to the petitioner, that is in the bottom of the miscase. But now that the entire construction has become unauthorized, that is entire plot number 147, page 4, my lord, page 4 of my writ petition.
Construction of pond, if any, over plot number
My lord, next page.
147.
Plot number 147, area 19.250. Page 5.
Area?
Page 5, my lord. Page 5 towards the top.
Yes, plot number 147, area 19.250 decimal. Isam Panipota, Khata number 329. Okay. Till next date. I'm keeping this.
Lordship.
You have a copy with you.
My lords.
All right, instruction memo file and the communication letter filed here, which we kept on record.
Lordship, may I pray, let the executants of that work order, let them be appended as a party, because if we have not sanctioned in
In the
their.
meantime, you also
I'll
make him a
inquire.
party.
My lord, I'll inquire and make him a party.
So God knows who has issued work order even.
No, work order has been issued departmentally.
And without, okay,
But
work
after
order
that-
issue habba kono, can it be issued prior to layout finalization?
No, in the work order, it has been specified that they will start after drawing design specification as per direction has been provided to them.
Work order annexure?
That is there, Your Lordship, at page 21, annexure 3.
Okay, from page
Of the writ
21
petition.
annexure 3, it becomes clear the work has to commence after the layout approval is there. Tapore lekhibo from para 3C, there is a clear disclosure, say patala.
Item 17.
May I please, madam? The petitioners are the
Yes.
Naib Sarpanch and the ward members of SAHOO Gram Panchayat under Bhadrak, my lord. Madam, the present petitioners, may I draw your lordship's kind attention to annexure 1, my lord, page 13, my lord.
Right, this is in the matter of construction of a
Kalyani Mandap, my lord.
Kalyan Mandal.
Kalyani, there is a stipulation and guidelines of the government under annexure 1.
Each village will have Kalyan Mandaps.
My lord?
Each village will have Kalyan Mandaps.
Each Gram Panchayat have Kalyani Mandap,
Each
my lord.
Gram Panchayat.
My lord. Page
And-
30.
And up to spending of 6 lakhs.
My lord, may I draw your lordship's kind attention to page 13, my lord?
Yes.
Page 13, my lord, the government of Orissa Panchayat Raj Department had issued the guidelines, my lord, to all the collectors and the PDDRDA. Well, the model estimate for construction of Kalyani Mandap Community Hall, crematorium and ladies bathing ghat with linten at GP level, my lord. I am concerned with the Kalyani Mandap. So far as page number 14, may I draw your lordship's kind attention?
Kalyani no, seta Kalyana.
Kalyani Mandap. Kalyani Mandap.
Kalyani is the name of a girl.
Sorry.
Kalyana is blessing.
Bless 14, my lord. This is
Right,
the
but
specific.
who are you?
We are the Naib Sarpanch and the Gram Panchayat ward member.
No, but you have not filed in that capacity.
My lord?
You have not filed in that capacity. You have filed in individual capacity.
Individual. We are the.
So therefore, why you say we are the ward member or anything else? So you are few villagers.
Your lordship made it in light.
What is your obstruction? No
My lord,
objection even.
my lord, page 18 may draw your lordship's attention, my lord.
Yes.
The estimate value, that is 35 lakhs, my lord. 35 lakhs. Then subsequently, under annexure 2, my lord, on 31st/3/2016, my lord, the state government was pleased to enhance the amount.
Right.
May I read out, my lord?
Enhance the Heichi, who disputes that?
Enhancement.
Yes, there is enhancement.
So
what is the problem now?
In addition to 35 lakhs, the state government pleased to enhance the amount. I may be allowed to place, my lord.
You come to the question, how are you agree?
My lord, the Kalyani Mandap has to be constructed as per the model instruction of the government of Odisha, my lord. Here, the Gram Panchayat, Sarpanch and the PEO, without following the same, they want to spend the.
You made a complaint on that. What is the position of Kalyan Mandap now?
Annexure 4.
My annexure 4 is the complaint, my lord.
Your complaint.
My lord.
Now, what is the position in the construction?
They want to, they are ready, they are going to construct the mandap, my
They
lord.
have already gone forward or they are
Forward.
gone forward.
My
So spending, what will happen to the spending?
My lord, my submission before your, my lords, my lord. they have not, there is no funds with regards to Kalyani Mandap, first land, my lord. As per the instruction of the government, so
It is
35
their headache, ଯଦି fund ନାହିଁ କଣ ଅଛି ସେ କେମିତି ତିଆରି କରିବେ?
10 ଲକ୍ଷ ଟଙ୍କା SFC fund
ଆପଣଙ୍କର କିଛି ସେଥିରେ ବଦରେସନ ନାହିଁ, ଆପଣଙ୍କର ground ହଉଛି that there is violation of
annexure 1, 2 and 3, my lord.
1, 2 and 3.
My lord.
So they will keep it in view and take a decision. but
Annexure
no
4.
stay. And submission of Sri Madani, Learned Council appearing for the petition. Petition involved following prayer. Even though an attempt is made to draw the attention of the court that the construction of the Kalyan Mandap involved herein is contrary to the provision meant for. However, in the course of submission, this court find petitioners have already raised their complaint before the collector and chief executive officer Bhadrak, pending for consideration. At the same time, this court records the submission of Sri Madani that the construction work has already commenced. Be that as it may, for the pendency of the complaint of the petitioners with the collector and chief executive officer Bhadrak, OP number so and so. This court in the finding the writ petition premature at this level. However, direct the collector and chief executive officer Bhadrak, OP number so and so, to look into the complaint of the petitioners involved herein and give a lawful disposal to the same. Construction, if any, in the meantime shall remain, however, subject to ultimate outcome by the collector and so and so.
My lord, can I assist your lordship? One line, my lord. The annexure 1, 2 and 3 all are violated, my lord.
Decision process will also keep in view the guideline through annexure 1, 2.
2 and 3. Oblige, my lord.
ଏଠୁ ଗଲା ବେଳକୁ ଅନ୍ୟ କୋର୍ଟ କୁ 100 ଥର କଲ୍ୟାଣ କହିକି ଯିବେ. So that you are not repeating this again in
Kalyani Mandap, my lord.
Kalyana Mandap.
My lord.
That's a Sanskrit word.
Yes, my lord. Deeply obliged, my lord.
Yes.
Here in this case, the petitioner applied for settlement of his land, which he purchased in the year 1983. Purchase was issued by the annexure 3. Similar matter, your lordship has directed to raise the objection and the same shall be considered.
All right. ଆପଣ ଓଲଟା କାହିଁକି ଆସୁଛନ୍ତି? ଆଗ ସେଠି ଦରଖାସ୍ତ ନକରି ହାଇକୋର୍ଟ ପଳେଇ ଆସୁଛନ୍ତି.
Item 19.
I have challenged the revision application that has been dismissed.
Audible ହଉନି, ଆଉ ଟିକେ ଆଗକୁ ଆସନ୍ତୁ.
Revision petition has been dismissed. 15B application.
Is pending.
15B dismissed.
15B against I am not entertaining petition.
They are saying that I have not produced documents. I have produced all the documents.
You have produced, then if it has
the
gone
ground of
against you, go to
license.
civil forum.
Here,
Go to civil forum. If you say if you have produced and he is ignoring, then go to that forum to file a review application.
here civil would not be, because it is a clear case.
No, you have two limbs of submission. One, that in spite of your filing document,
No, I have filed
he is
my
ignoring.
registered cell deed. And also I have filed the 1929 settlement. It is a Jagir service land.
See the page 24. Come to page 24. Read here.
24.
You are the petitioner there?
Yes.
Yes, 19(1) order ta padundu. The counsel.
The counsel for the petitioner is present. Counsel for the opposite party number 127 is absent. Third, the counsel for the petitioner is directed to produce original documents and relating to case and also relevant order, who is the Jagir lands has been settled. So Jagir lands is not.
So that was the direction.
Direction, and I have produced all those documents. Except the Jagir.
Okay, now what he says you have
says
not
that
produced.
how it has been converted in my vendor's name as royalty.
Page 25, your lordship can have a look. In fact, it's a non-speaking order almost. Because direction was that he will produce. The next order is pronounced today, accordingly the case stands.
Thereafter he has given the detail order.
Detailed order.
Page 26, 27, detail order.
Yes. That last portion I am reading. For the proper adjudication of the matter, the counsel for the petitioner was.
If you say that, Mr. Nanda, if you say that you have produced records, then you have to ask that court to recall this order.
But Jagiri, whether Jagiri lands, there is no settlement. Question of settlement does not arise under section 8. So how can I produce that Jagiri land?
No, that is the only lacking.
Only lacking.
That is the only lacking.
Because I have produced all those documents.
Okay,
Annexure 1,
Mr.
etc.
Nanda may be justified saying there is no requirement of settlement of land. So therefore, there can't be any order there.
Jagiri land is order.
Yes. Parchata khali jadi deidabo Jagiri land, that itself is sufficient. And Parcha, as appears, he has filed.
They have also recorded.
Issuing notice.
They have also recorded the name of the vendors as royalty.
Order, impugned order in revision petition 332 of 2020 has been assailed only on the premises that when there is no scope for settlement of land in favor of the Jagir lands and preparation of record of right accordingly, there is no possibility of producing such record. It is thus alleged the revenue authority, the competent authority did not consider this aspect. This court find a prima facie case in favor of the petitioner and is inclined to issue notice. Requisites accordingly, place the matter.
Private parties private parties are also there.
Private party also there.
Item 2, opposite party 2 to 8.
Okay, matter be placed after the appearance on the private parties 2 to 8 completed.
They have no objection. The private parties have no objection.
Private
because they are
party, you have to
vendors.
take notice on them. File by day after tomorrow.
Item 20.
In the meantime, the records be kept ready with the state council. Records in case numbers. And to find out if there is at all any document favoring him. Yes.
In view of Narottam Ratha case, I have filed a case before the ASO regarding correction of the ROR. Did not accept the same.
He is not accepting more order kind. कौन है जी ताको कथार्ता करंतु से एसो को इंस्ट्रक्शन दियंतु से काई मना कर दोची झरका पाखरे भी
से कहउछन से 41 केसेस होईची सेउडा केवल एक्सेप्ट करिया अदरवाइज हाई कोर्ट रो ऑर्डर आनी
तो I have clearly observed maybe a different aspect on the merit. You may reject it as not maintainable.
Yes.
But really, same order.
2021 22 23 चारटा
का
Indirectly ताको में blessing no halaru se asig file करले lawyer by blessing.
The benefit is there definitely. There is no doubt, but burdening High Court unnecessarily.
Item 24.
Yes, 24.
24, I don't know, but the petitioner seeks an early disposal of the RP number 376 of 19 pending.
If the proceeding has been admitted.
No, the petitioner, the sole petitioner who has filed the case has died in the meantime.
So fresh admission for a young counsel Janipanna.
The matter has been transferred to Jaspur, but the record has not gone to Jaspur.
There are two RP cases.
Paragraph 2.
No, there are two prayer person. There are two RP.
So fresh admission fine they do.
There are two RP cases.
Two RP cases.
Yes. One is 376 of 19, the another is 376 of 2023.
I say 19 or 23.
No, quota tale, quota press.
19. 19 টা 23
19 টা press করিবে
23 ভুল হলে টাইপোগ্রাফি হলে
repetition is confined to RP case 376 of 19.
19
So far it relates to prayer number 3 is concerned. Okay, considering the submission of the respective council, this court directing the event. Now this 376 of 19 is transferred to
Jajpur.
Okay, just
Opposite but not to.
The Jajpur authority is directed to show lawful disposal to RP 376 of 19 by completing such proceeding at least within a period of 4 months. Prayer number 4 is kept open to be, if agitated in a different writ, shall be considered there only. Yes.
Item 25.
Yes. What is your representation?
My lord, annexure 5.
Settlement of land
OGLS.
on OPL.
No, the request is in order to avoid the unauthorized encroachment. I had requested the special principal secretary for allotment of said piece of land. So settlement of land. Settlement of land, where is the scope for representation? It is not under OGLS. OGLS upon darkhast dei paribe secretary nu. Now in the
No, under any scheme, my lord, I am using since
In
19.
first page of the cost title, in the matter of an application.
Yes, OPLE. OPLE proceeding. OPLE proceeding involve appears you are an encroacher.
Some part of the year, the adjacent to-
Then you go in OPLE
My representation is pending. May I kindly be considered.
from the cause of action as well as the representation, it appears the matter involve OPLE Act. Provisions of OPLE Act. Rest is directed to place the matter accordingly. Say court ku jibo, je OPLE take up korchon.
Item 26.
Might please lordship.
Yeah.
Applying for the early disposal of regulation appeal number 1 pending before
This has
ADM.
been admitted or not?
Admitted, my lord.
Already admitted.
Already admitted, and then this is a
This
matter.
court records the submission of Learned Council that regulation appeal 1 of 22 has already been admitted. Okay, this court accordingly direct the appellate authority to show a lawful disposal to regulation appeal 1 of 22 at least within a period of 4 months from the date of communication of order.
Obliged, your lordship.
But in the involvement of the party likely to be affected.
Item 27.
I may pardon, my lord, that instead of TS, CS has been mentioned in my.
No, you challenge
Challenge.
for implementation.
My lord, the judgment of the civil court already passed, my lord. I presented before the Tahsildar Barangara.
Then execution?
Execution was filed. That is the.
No, where is the scope for High Court giving such mandamus?
No, my lord, that is the ROR is still continuing in name of, that is delete the name of the ROR. That is judgment I presented before the Tahsildar. He is not accepting. The certified copy of the judgment, my limited.
Suit has been dismissed. Suit has been dismissed.
By the plaintiff, filed by the plaintiff Fakir Behra.
Okay, then you file a mutation application.
My lord.
Then
No.
What is the cause of action here?
When I am going to present the certified copy before the Tahsildar, my lord.
For what?
To delete the name of Fakir Behra in ROR, my lord, because you are defeated. He is not accepting the certified copy. My simple prayer to I may be permitted to present
No,
the
then you may come in a mutation proceeding.
My lord, that may go.
So why are you posting this?
I
ଆପଣ ଯିବେ ତା ଅଫିସରେ ବସିବେ କହିବେ ଆଜ୍ଞା ଜଜମେଣ୍ଟ ହେଇଛି ଆପଣ ସୋମୋଟ କରିଦିଅନ୍ତୁ କେମିତି ହବ ସେଟା ହବ 37 ରେ ହବ ନହେଲେ 15B ରେ ହବ
My lord, I may
ସିଭିଲ କୋର୍ଟ ଡିକ୍ରିକୁ ସିଏ କାହିଁକି ଧରିକିରି ତା ବନ୍ଦୋବସ୍ତ କରିବେ and when the suit is dismissed ଡିକ୍ରି ହେଇଥାନ୍ତେ କି ଗୋଟେ କିଛି ଅଛି ଯେ
that was dismissed by the
counsel for the petitioner wants withdrawal of the writ application to pursue his remedy available remedy under the mutation manual and or the Odisha Service Settlement Act. With this liberty are permitted to be withdrawn, however with liberty. It is subject to cost of ₹3,000 to be paid to Bar Association Welfare Fund. आपन बयस केते हला?
My lord, that is not my simple prayer.
नहीं नहीं आपन को बयस केते हला?
My lord, 60.
बयस केते? लुचन दुनी. बायावराव नहीं.
68, my lord.
68. 68 रे आपन ये केस करिवे आपन जूनियर गले को छडु.
No, my lord, it was some brief of my junior that the client comes from Baranga. When they go to Baranga Tahsildar, he not at all.
हला ठीक अछि आपन जूनियर कलानी आपन कहीं कॉलेज सेठी में बार एसोसिएशन को देबे
No, my
जूनियर
lord,
पैसा देना
he is here to argue.
काई कां दे
My lord.
कोठी
Madam, he पिला कहले त ठिया
ये आपन को जूनियर आउरी अछंती आ केते वर्ष आपन को जूनियर रहिबे छी
obliged, my lord. I may be permitted.
काटी दे
No, I believe. The petitioner challenged the inaction of the opposite party number 2 in not demarcating his name, his plots, and
please be on mic.
Down to Annexer 4, the last representation to the Tahsildar, till that he has not demarcated the land.
Demarcation पे तो have you instituted a demarcation proceeding?
Application नहीं से Annexer 3 से देइछन notice देइछन.
Annexer 3.
My lord. Page 19.
Page
19. Page 19.
19. Okay, then why have you come to High Court?
They are not demarcated till yet.
Okay, considering demarcation case number 57 of 22 pending long since. This court in disposal of the writ application direct the Tahsildar Badbil to give a lawful disposal to the same, however, in the involvement of boundary tenants, at least within a period of 3 months.
Item 29.
Item 29, my lords. I filed my appearance memo, my lords, I filed today. My lords, kind of a glance to page 49. This is a nursing home. It was seized under Clinical Establishment Act. Against that, my lords,
De-empanelment.
it is de-empanelment. I'm coming, my lords, kind of a glance to page 49. This is sealing of the clinical establishment.
Yes.
Against that, I have come before the Hon'Ble Court. Hon'Ble Court was pleased to pass the order in WPC number 7516 of 2023. Thus, interim order is continuing. Seizure is there because they have to file counter, regent has everything filed, and that now it is for hearing matters. In the meanwhile, what happened? After going to the counter, we found that because this is a nursing home, it was availing BKSY scheme. Now, what they are doing is, kind of a class 2, in counter, they will enclose the document. That is what it is a separate cause of action because this is not coming within the scope of Clinical Establishment Act. That is what we are constantly.
They are suspending.
Not suspending, Annexer 8.
Here, de-empanelment.
The collector recommended for a de-empanelment. I have not been de-empaneled. Fact remains, once de-empanelment knows that restoration is a very difficult task. For Annexer 8, page 50.
Then other it involves what?
Cancellation of the license under Clinical Establishment Act.
So there is cancellation already.
There is cancellation of the seizure. Seizure of the total nursing home has been seized.
Seized.
Now, pending of that.
Meantime, it asila de-empanelment.
De-empanelment will be processing.
Okay, ताको add कर दो ता संगे
हाँ, this is a case added.
Lordship may only see the reasons why this Annexure 8 has been passed before your lordship granted the interim
the
order.
same reason. Super clinical established cancellation. This is the same reason.
Here it has been specified that there have been many complaints that have been received. Your
Exactly. That is the cause of action.
If you receive a complaint,
Lordship.
then should you not involve you in an inquiry?
Yes.
So this
and
report,
involve them.
Lordship, this report has been based on a random visitation that has been conducted.
My lords, I have in that writ application.
That report is also there. Your Lord.
Is it an order amounting to punishing a institution or not?
They have only stated that they are not rendering adequate treatment and care to the patients
Then should you
admitted
not
under.
involve them to find whether allegations are true or not?
Ultimately, they should be involved, my lord.
So therefore, let us hear. Let us
Lordship.
hear. I am not hearing today.
My lord.
Let us make it analogous to the other proceeding. In the
Lordship.
meantime, if you have any objection, bring it.
Lordship.
Yes. Chutti pare dita ka matter aslo. Eta
Along with that,
direction is.
along with WPC number 7516 of 2023.
In the course of hearing, the read petition, this read petition involved de-empanelment of the petitioner from the
No.
BSKY na BKSY? BSKY scheme run by the state. However, there is also proceeding on sealing of the petitioner institution pending right WPC 7516 of 23. Okay. Issue notice on the question of admission. Copies accordingly. Counter, if any, be filed within 3 weeks. Place this matter along with WPC 7516 of 23. Second week of July. 11th of July.
Still then, no action may be taken upon Annexure 8 minus. No decision may be taken upon Annexure 8.
Okay.
The BSQ available.
In the meantime, there may not be any further coercive action against the petitioner pursuant to Annexure 8. How can you ଭିତରକୁ ନେଇଯିବେ ବୋଲି ଭାବୁଛନ୍ତି?
No, thore cancel ହେଇଗଲା ପରେ restoration becomes very difficult. Suppose I succeed in the clinical establishment act case रे
କାହିଁକି ଏ ସବୁ କରୁଛନ୍ତି?
ସେ ପ୍ରକୃତ ଜିନିଷଟା ତା ନୁହଁ। ଜିନିଷ ହଉଛି ତାର 2 ଦିନ ପୂର୍ବରୁ ଯାଇକି କହିକି ଆସିଛନ୍ତି ତାଙ୍କର କମିଟି ଯାଇକି କହିକି ଆସିଛନ୍ତି ଆର କେସ୍ ରେ have given everything is okay. Only one person, he has come in a very difficult position. I recommended them to go and.
These submits, there are a number of.
No, that is not correct at all. Not based on fact, my lords. With due humility.
All right, you file your counter.
Lordship will file.
I beg to submit, my lord, the original certified copy already filed.
Okay, so case for then certified copy return. Yes, next.
My lord. These are 18 mutation
Item
case.
30.
Pending notes. Early disposal. These are 18 mutation case. Mutation case of 2018.
2018, that is based on a judgment and
Yes,
decree.
yes.
Okay, it is alleged by way of writ petition that that mutation case 267 of 18 instituted in the year 18 and based on a civil court judgment and decree is still kept pending. Considering there is inordinate delay, this court is disposing the writ application, direct Tahsildar Noyagarh to give lawful disposal to the mutation case 267 of 2018, at least within a period of 2 months from the date of communication of order.
Item 31.
31, may I please your lordship, my lord? Here, my lord, I have filed a demarcation case, my lord.
Okay, already demarcation case order. But however, involving the boundary tenants, if any. Yes, within 2 months.
My oblast.
It's a fresh case, your lord. So 2023 matter and notice has already been issued to the private opposite party.
Demarcation କେତେ ସମୟ ଲାଗିବ? Boundary tenant କୁ notice ଦେଇ ଖାଲି ମାପଟା ନବା କଥା.
Lordship.
So 2 months with the notice ବି ହେଇଗଲାଣି କହୁଛନ୍ତି.
My lord, notice is there, annexure 4 page 90.
ଆଉ ଜଲ୍ଦି କହିବା ବୋଲି କହୁଛନ୍ତି.
No.
Oblast.
Yes, Mr. Naik, you have also put up sufficient experience. Why are you arguing these matters?
Look, 32 here, the petitioner's property, they were evicted by the state government on the ground that there will be a construction of Anganwadi center. The Anganwadi center was constructed. We objected that there's no authority, there's no notification. They said, don't worry, we will give you compensation. We waited for them to give compensation. Now we made a representation at Annexure 4. Annexure 2, my lord.
Construction already
Construction completed, we were evicted. Now, when we approach for compensation, you either give us compensation or
let there be lawful disposal to Annexure 2 series.
Lordship.
Annexure 2 series.
As it is, if they are truly aggrieved, they can file a civil suit, your lordship. That should be the true remedy.
କାହିଁ ସେ civil suit କୁ ଯିବେ? ଯଦି ତାଙ୍କର record ଅଛି, ତାଙ୍କୁ eviction ହେଇଛି, compensation টা দিয়ে দেওয়া কথা article 300A নহলে violate হলা either you occupy or leave them to occupy. If you occupy, then only source is compensation. Here is a allegation that you have assured them to be compensated.
But
Then
they have
you-
not filed any documents on that.
We waited from more than 1.5 years we waited. Now we
But
approach.
are you sure this,
My
for
lord, my
this land, nobody else has been compensated?
No, my lord.
So you give a lawful disposal. Suppose
Lordship.
somebody else is already compensated, then you may decline their request.
Lordship.
Or else you may ask for proof. What is that material to show you that at least establishing that they had earlier
My lord,
permitted you?
my lord, in the averment's writ petition averment we have mentioned, and
Petition have-
also in the representation we have mentioned.
Recommendation, where is the copy of recommendation?
My lord, annexure 2 series at page 20, if your lordship sees.
Yes, please read that part. This was communicated to
To the collector and district social welfare.
internal communication.
No, my lord, this is a representation, petitioner representation.
This is representation.
My lord,
So in the representation, you have disclosed that.
we have mentioned that we waited.
All right.
My lord.
Yes, prayer court karo, having considered the rival contention, this court find in disposal of writ application, there should be direction to the collector and district magistrate council for giving lawful disposal to the request of the petitioner by annexure 2 series, page 20 onwards. Okay, the writ petition accordingly disposed, directing the collector district magistrate Keonjhar OP number so and so to give a lawful disposal to the application by annexure 2 series, page 2021 herein. By completing such exercise and in the involvement of the petitioner at least within a period of 3 months from the.
Lordship.
Obliged.
Yes, yes.
Item 33.
May I please, your lordship? This is the petitioners are the villagers of Aradag, Moja, and the main claim is that they have not given the possession of their chokos even after the publication of 22 to ROR. And I have represented her on the annexure 2.
Okay, the writ petition involves.
Lordship, here if the section 41 notification has already been issued.
Not issued, my.
Then the power is with the Tahsildar to hand out the chakas, your lordship, as per section 25(4).
Advise them accordingly.
Lordship.
They have a pending representation.
Well, it's because once
he finds there is section 41 notification not there,
Lordship,
you may direct them accordingly.
my lords, they have to pursue section 25(4) after that.
Habo ki nahi?
Heini, but no, 41 Heini. Current 40% villagers to
Lordship,
diya
but
hai.
observe if section 41 has not been issued,
Okay,
41(1).
okay, all right. The petition aiming disposal of lawful disposal of representation of the petitioner at annexure 2 involving non-issuance of non-allotment of choko.
Yes, madam.
Non-allotment of choko in spite of sorry, consolidation operation in the area already completed and chokos.
ROR has been published.
Chokos have been carved out. State Council Sri Sonok Mishra, however, submits in the event the proceeding already crossed section 41.
41(1), your lordship.
41(1) of the OCH and PFL Act states petitioners are required to approach the competent authority and no representation. Representation as at annexure 2 may not come to their rescue. The Rathal and council appearing for the petitioner makes it clear that there has been no issuing of 41 notification as of now. This court observe unless there is issuing of 41(1) notification in the meantime, let there be a lawful disposal, the outcome to the representation of the petitioner by annexure 2 in the involvement of the petitioners and working it out at least within a period 4 months. So many persons are there.
Keeping in view annexure 1.
The free copy of order is handed over to.
Keeping in view annexure
Mishra. Yes.
Item 34.
My lord, I have a captive port at Paradip. And my lords,
At page 176 minutes, I had come to your lordships before once, and at page 176,
Yes,
the Paradip Port Trust, my lords, 2nd December 2022,
yes.
they fixed a scale of rates for various services. Now, according to us, my lords, this was contrary to the policy which your lordships will see at 139. At page 139, there is a Government of India policy. My lords, have page 139 minutes.
Yes, yes.
3rd November.
Hmm.
And that policy, if your lordships kindly turns, my lords, to page 140, kindly see, my lords, page 140,
Yes.
Roman 5, based on the report of the committee constituted by IPA in pursuance of section so and so, the Government of India hereby issues the following policy.
Hmm.
And the relevant page, my lord, is page 142, 2.10. My lordships have it?
2.10.
Tariff arrangement. My lords have it?
Yes.
Tariff arrangement for captive berth facilities, where a separate tariff arrangement is prescribed in mutual agreement entered into by the port and the concerned user, will continue to be governed by the respective agreement. So, Jahara agreement, agreement will continue.
Yes.
In the event captive berth is awarded in future.
Earlier.
Yes, I am coming to your lordship's order now.
Yes.
If your lordship sees page 212, I had made a representation.
Yes, I had directed for consideration.
Yes, your lordships are directed for consideration. Your lordship may see page 214, and at 215, my lord, your lordships had said in paragraph 5, page 215.
Yes.
Bringing reference to the tariff notification at page so and so of the brief issued by Paradip Port Trust, Finance so and so, read together with conditions at pages 44, submits that the new tariff should have application to the prospective assignees and not to the continuing assignees.
Right.
In course of submission, this court finds that petitioner has already made resistance by annexure 8 at page so and so of the briefs issued on so and so. For prima facie satisfaction, though the clauses referred to herein above, this court feels it appropriate for consideration of the objection of the petitioner herein.
And there shall be no coercive action.
And there shall be no coercive action. Now, kindly see what they do. If my lords will now kindly turn to page 257.
Yes.
My lord, in a very cryptic manner, without considering my grievances,
You are existing
my
assignee.
representation is disposed.
You are an existing assignee.
I am an existing assignee, admittedly. If your lordship's page 258, my lord, your lordship write down. The Paradip Port Trust itself writes at page 258.
Yes.
The submission of PPL revolves around clause 1 of the agreement dated 3rd August 1985. My lords have it, my lord?
And it is to expire on?
And my lord, it is continuing. Now, what I want, I will not trouble your lordships. What I am only saying is that if your lordships kindly has a look at the Port Trust statements. Copy what I will do. Port Trust Act got achi.
Port Trust Act.
Again. And I have
Then
given a copy.
What they have done here?
My lord, they have rejected my representation.
Rejected.
Yes. My lord, they have rejected my representation. There is no point going back to them. I have given your lordships one act, the new Major Port Trust Act. Kindly see section 54 minutes.
Yes.
If my lords kindly sees page 18, say Abhika Delhi Act upon this.
Yes, 54.
The central government shall by notification, my lords have it?
Yes.
Constitute with effect from such date as may be specified herein, a board to be known as the adjudicatory board to exercise the jurisdiction, powers and authority conferred on such adjudicatory board or by under this act. Kindly look at my lord, proviso. My lord, until now there is no adjudicatory board. Provided that until the constitution of the adjudicatory board, the tariff authority of major ports, which is TAMP, constituted under section 47A of the Major Port Trust Act 63.
So you say this is without jurisdiction.
I am saying that this order is bad and it has to be referred to the constitution of adjudicatory body.
Okay, then let us involve them.
Yes, fair enough, my lord, no difficulty.
Is had. In the constitution process, Sri Ashok Parijal learned. You are appearing as a senior counsel.
Yes, my lords.
Senior counsel appearing hearing. In reference to section 54 of the Major Port Trust Act.
Again.
Major Port Trust Act submits on the issue of tariff. Proceeding has to be first of all decided by adjudicatory board. However, for the proviso therein, in absence of adjudicatory board, the tariff authority for major ports constituted under section 47A of the Major Port Trust Act 1963 shall discharge such function. Shall discharge the function of the advisory board. It is next taking to the authority passing the impugned order herein. Impugned order is annexure
257, my lord, annexure 20.
Hmm. 257. 257, yes.
Annexure 20, my lord, 26th
Annexure
April 23.
Challenge the competency of the authority involved herein. This court finding a prima facie case direct for issuing notice. Okay. Requisites accordingly as undertaken by day after tomorrow. In this case, notice as above. In the meantime, there shall be stay of operation of the order at annexure 26. Yes.
The lordship may see page 215. 215, page 215. Interim order touch. There should not be any coercive action, tariff notification.
There is already.
That
granted interim order.
Yes.
I've stayed annexure 20.
Lordship pleases.
That interim order was to continue till they passed the order.
Again, lordship please.
Now there is fresh cause of action. So.
We'll file requisites by 3 days.
Item 35.
May it please your lordship.
Satyakam.
Yes.
May it please your lordship. My lord, the petitioner before your lordship is a developer.
Item 35.
Yes,
Yes, madam. May it please your lordship.
Yes, 35, Mr. Patnaik.
Yes, my lord. My lord, the petitioner is a promoter.
Nobody is present after.
My lord, we are present, my lord.
We are
Oh,
present.
you are on DC.
Yes, my
Yes,
lord.
my lord.
All right. Yes, Mr.
I'm sorry,
Patnaik.
my lord, I am.
Yes.
My lord, the petitioner is a promoter and developer, my lord, of real estate. My
Yes.
lord, here the point canvas before your lordship is, there are two parallel proceedings going on in respect of the same subject matter under the OPID Act and under the RERA Act. So in the RERA Act, my lord, there is a regulation, there is a column where complaint is to be filed that they are to disclose if any other proceeding are pending before any other court. My lord, they did not disclose it. And my lord, now the RERA court my lord proceeded. I am inside, I was taken under custody under the UPID Act.
Yes.
And they proceeded under RERA Act, my lord. And this is now at the stage of execution.
Now it is only pending. The
My
RERA
lord,
proceeding is only pending.
Yes, my lord.
So
Execution case, my lord.
if you challenge the RERA proceeding,
Yes, my lord.
then why are you not bringing such objection there?
Yes, my lord.
My lord, I filed an objection.
So what is the stage now in the
At
RERA
the-
proceeding?
My lord, execution has been started and OPDR cell certificate also issued, my lord.
Pardon?
My lord, certificate case already been started, my lord, by OPDR.
Before the RERA authority?
Yes, my lord. Yes, my lord. My lord, and they are stating that OPDR and RERA proceedings are two distinct proceedings.
So
Whereas
therefore there may be continuing of such proceeding.
Yes, my lord, it is going on continuing, whereas in OPID, attachment of all the properties are being attached. and they are also going on attachment with the self-same property, my lord. My lord, in all cases.
So your submission as per submission of Mr. Patnaik, Senior Patnaik,
Yes,
there should not be parallel proceeding continuing.
Yes, my lord.
Now, what is the RERA proceeding pending here?
My lord, Annexure 5, the execution proceeding is going on. Annexure 5, my lord.
But since it is a OPDR proceeding, you can bring the no denying liability, or you don't want the proceedings to continue at all.
Yes, my lord. That's my prayer before your lordship.
So
Because the
your
result is the same.
So your submission, your all properties are already there in OPDR.
They are already on attachment by the OPID code.
Okay, Mr. Patnaik, you may make it clear. OPDR is a different issue. OPDR is you are in liability of some private persons.
That they have sent it, my lord.
Now RERA is maybe you have constructed some building and you are not giving it a finality.
Self-same property.
Self-same property, my lord. Which has
Self-same
been
property,
attached.
no doubt. Self-same property, no doubt. But how you obstruct the OPDR proceeding here? It is definitely by the consumer.
My lord, how I will pay, my lord? All
No,
the properties have
that's a
been
responsibility
attached.
of your client only.
My lord, OPID, all attachment has been done.
See, Mr. Patnaik. Let us assume all your properties are in the custody of the OPID.
Yes, my lord.
Okay. Now, even if this proceeding continues,
yes, my lord,
what they will be attaching?
Civil imprisonment.
My lord, civil imprisonment.
Civil imprisonment will be there automatically.
Yes, my lord.
Yes, my lord, your lordship is right. Some protection can be given to me, my lord.
No, I am just searching that. What relief can maximum be given to you?
The execution cases may be stayed, my lord.
No, why don't you bring that quota section 8, no denying liability?
Section 6.
Section 6. So you bring a section 6 objection, and till they take a decision on that, there will be no coercive action.
All right, my lord.
But why don't you apply OPID to release some property at least?
My lord, I will apply.
My lord, we'll file a for release of some properties in the below.
So in the meantime, you arrange something, otherwise both the proceedings are definitely have different dimension and at the instance of different type of people. OPID, is it a proceeding at the instance of the
same complainant, my lord?
My lord,
same complainant?
Yes, my lord.
Yes, my
That
lord.
is the whole issue, my lord. All those who are charge seated witness in the OPID case, they have filed RERA cases. And there is a clause in RERA case, my lord, they have to disclose. If they would have disclosed that, then RERA would not have proceeded at that time.
Okay, Sri Patnaik had the submission of Sri Patnaik, Learned Senior Counsel, along with Mrs. Patnaik. Sole challenge to the notice to certificate data in OPDR 08 of 2021 by page 119 of brief appears to be there has been two parallel proceedings at the instance of same set of complainants, one being undertaken by the authorities under the OPID, by the OPID code. And in the proceeding before it, there is already attachment of all properties of the petitioner. Involving the challenge to the OPDR proceedings, Sri Patnaik submits there is virtually no property left with the petitioner to be taken into task in the OPDR case 08 of 2021. This court appreciates the submission of Sri Patnaik that both the proceedings undertaken have different rigors. It is at the same time, it is also to be considered as to if the complainants prosecutes the accused or the petitioner herein before two competent authorities on same issue, and properties of the petitioner is already attached in the OPID proceeding. If the OPDR case 08/2021 can get a lawful disposal, it is at this stage, considering the stage of filing the writ application, this court find petitioner has a clear provision for bringing denying liability application and or objection under section 6 of the OPDR Act. Finding the stage of the filing here premature, this court, however, permit the petitioner, and in the disposal of the writ application, this court permit the petitioner to bring its objection, also detailing therein of the properties of the establishment and properties under attachment in the OPID Act. By filing such objection at least within a period of 3 weeks. In such event, the collector cum certificate officer for the undertaking the OPDR exercise shall first consider the necessity in continuing with the OPDR proceeding in the continuance of the OPID proceeding already involving same complainant, and then proceed in deciding the merit. Okay. Till a decision is taken on the objection of the petitioner, there may not be any coercive action against the petitioner so far it relates to OPDR case 08/2021. This observation, the proceeding stands closed. Yes.
My lord, can I submit? Can I pray? My lord, another thing arising out of complaint case number 128/19.
There is another repetition.
No, my lord, that OPDR case from which it has been.
RERA case, my lord.
Okay. Arising out of
One
OPDR
complaint case number 128/19.
Okay, see the certificate case OPDR number so and so that
Arising out of.
arises out of complaint case number 128/19.
Yes, my lord.
Have you challenged this order in appeal?
My lord, in appeal, the problem is that we have to deposit whole amount, my lord. My lord, in this matter, 44 to 50
But so
customers
there
are
will be
there.
serious problem if you don't challenge the complaint, the order of the original authority, then you are bound by that.
My lord, the whole problem is that we have to now again deposit all the, my lord.
That can be taken care of. You file application, let them reject the exemption, then you may come to High Court and High Court may consider that there is already attachment of all property you had from this man.
My lord,
You involve a challenge to the original order.
my lord, I bow down, my lord. but the
Otherwise,
thing
there
is
will
that
be difficulty in future.
Yes, my lord, I bow down, but the appeal won't be entertained, my lord, without
Oh,
depositing all the.
yes. I have given sufficient words. You have to understand from that.
Yes, my lord.
Yes.
Yes, my lord.
Next.
Item 36.
Unless there will be objection by the complainant now, sir, they are not challenging the order. It has to be worked out. So therefore, find a block and a lawful block. You are in entitlement in filing an appeal.
Yes, my lord.
Entertained or not entertained, further courts are there. They will take this to consideration.
Yes, my lord, will do.
Yes.
Please, your lord. Here, my lord, I am
All right.
challenging the order
Thank
under.
you. Thank you, Mr. Patnaik.
Yes, my lord.
I am challenging the order under Annexure 8, which is passed, my lord. The grounds of challenge is para 3, your lordship can see. Para 3. The
At the end of
business
the
banning
day, all
order.
weak cases. Pardon? At the end of the day, all big cases. Advocate General, then Mr. Patnaik, ये गोटे 100 पृष्ठार फाइल दर्शन.
Your lordship, 100 पूजा किंतु दी पेज रे मो सर. Your lordship kindly turn
What
to
is the challenge
para 3, the grounds of challenge, my lord. They have,
No, what have you challenged here?
I am challenging Annexer 8, which is communicated
Page,
my lord, Annexer 8 at page 34.
34.
On the ground, my lord, there is some labor law violation. Labor law violation, one of the laborer made a complaint directly to vigilance after 3 years of his service that he has not been paid. When it is brought to my notice, I
So
immediately
you have been
repay.
banned.
I am a contractor.
You have been banned.
No, ban order is only communicated. There is a threat notice of implementation of the ban
But
order.
this was communicated since 11/11.
No, communication is page 11. That was my previous, it was not brought to my notice, page 54. And they have their own established procedures. This ban order cannot be passed for labor violation. I can point out your lordship, page 11 kindly, annexer 11 at page 54. This has not yet been, after this ban order, my lord, I have been entrusted several works. These 2 works, which they want to, they have given a notice indicating that they have recently received. Officially, as on date, there is no communication.
Here they are asking for show cause.
They are asking for show cause in respect of these 2. Annexer 12, your lordship, see, there are a series of tender works are pending. I am a 30 years contractor. And the procedure, your lordship, kindly see, very interesting.
You have a contest with railway.
I am contesting with the railway. Your
You
lordship,
are
kindly
there.
turn to page 43. Whether this is a ground of ban, that they have their own established procedure, sir. That's why they are not communicating this order. I was not involved in the proceeding. Neither the report of the vigilance was supplied to me, nor
This
given.
matter has not been entertained as of now.
Pardon, my lord?
This matter has not been entertained.
No, my lord, first time it has. First time.
Then take notice.
I am taking notice. Yes.
But what is the apprehension now? There may not be any
Annexer
further
12.
coercive. There may
Annexer
not
12.
be any further coercive
Yes,
action.
Annexer 12, Annexer 12, but these are all subsequent to.
Annexer 11, we may not, 12, we may not involve. We will say there may not be further coercive action pursuant to Annexer 11.
Yes, yes.
Same annexer, dated 11/11/2022, that order was earlier there filed the writ petition, double petition number 12499/23.
What happened to that?
And thereafter he had filed the writ appeal.
Because these documents
That
were
matter
not
is
supplied.
for,
These documents were not
He said
incorporated.
you have gone in a writ appeal.
thereafter he has filed the writ appeal. And then the matter, this writ petition is withdrawn. Thereafter again he has filed this writ.
With the liberty to file, because these documents were not Annexer 11, 12.
We'll take instruction in that.
There is no decision there.
No, there is no, because
Only at admission stage.
Take notice, let us adjudicate.
the
Jatadhari, कौन?
Jateshwar Naik.
Jateshwar Naik, na? Central government. You are alone or with Padhi?
Mr. Padhi is there.
Mr. Padhi.
जी,
बेको कौन हला? के मोड़ी दला का? केंद्र सरकार को बेको कर्नाटक रु मोड़ी हे गेला कि? There, okay, as an interim, there may not be any further coercive action pursuant to Annexer 11 without leave of the court. Place the
11.
matter on 4th of July. You are appealing for railway?
Yes, my lord.
Okay, as railway comes, sir.
11 and
You
12.
bring your counter in the meantime. There is allegation of non-compliance of
the
natural
level.
justice. Okay, if it is not done, then you advise your client accordingly.
No, we'll file the
And
counter.
involve him. Yes, Mr. Padhi.
Yes, we'll file the counter, man.
You file your
next.
counter. And if you find these allegations are genuine, you may advise clients accordingly.
Yes, yes, ma'am. We'll-
Annexer 12 is our
Because
own.
banning is not a small issue, blacklisting somebody.
Yes, yes,
So therefore, utmost care has to be taken.
yes. Before that, yes.
Annexer 12 series, my lord. These are all pipeline, my lord. They are not allowing me to.
So then, I'm saying there will be no further course of action, coercive action pursuant to Annexer 11.
Pursuant to Annexer 8.
That is sufficient.
So,
Annexer
Annexer 8.
8. Okay, Annexer 8.
Okay.
The petitioners were appointed.
Yes, somebody is saying.
For orders item 37.
I withdraw.
I can.
39 भी withdraw.
Again.
39 ta memo, 37 ta also. এটা correction କଣ ଅଛି?
My lord,
38 ରେ କଣ
para
correction?
2, Y number ଟା ଭୁଲ ହେଇଯାଇଛି।
ମେମୋ ତ କୋଉଟା ଏଇଟା କୋଉ କେସ୍ ର?
ଏଟା ସେ ଯୋଉ ଲାଷ୍ଟ କେସ୍ ର ମେମୋ ଆଉ ଗୋଟେ ଦେଇଛନ୍ତି।
39 ର ତ ମେମୋ ରଖୁଛି। ରାଇଟ୍ 38 ରେ କଣ correction?
ସାରେ ଆୟର para 2
That order has already been complied, your lordship.
Order already complied.
Lordship, we have filed a compliance affidavit on 14/2/2023.
There is finality to this proceeding.
Lordship.
ନା କଣ୍ଟେମ୍ପ୍ଟ ଇଏ କରାହେଇଛି ନା କଣ୍ଟେମ୍ପ୍ଟ ରେ ଅର୍ଡର କରାହେଇଥିଲା।
Okay,
26/2 ରେ କଣ୍ଟେମ୍ପ୍ଟ ଫାଇଲ୍
I'm probably holding wrong file. It's a content already.
ସାର୍
Yes,
ওই
he
নাম্বারটা
says it is already complied.
কমপ্লিট।
Yes. So they do the communication টা দেই।
I'll serve him a copy right now.
Okay, Sri Swarnak Mishal and her counsel appearing for the contempt now brings to the notice of this court that in the meantime, the order of this court has already been complied. Let there be communication of the development to the petitioner herein through his counsel. With the above recording, there is nothing surviving to be adjudicated. The proceeding finally closed with the termination of IA 3 of 23. Contempt agru sarjayich.
For addition item 40
Okay, 39 de dawa.
again.
14 on appeals. Nobody is showing interest.
Item 41. Item 41.
Yes, nobody is pursuing. Dismiss second.
Item 42.
Item 42, that matter, my lords, so the IOCL allotment matter, there, my lords, directed the government to serve a copy of the detailed report of Tahsildar. I also, just now I received the copy of the report, my lords.
42 more.
What, huh?
42 more. 45.
No, 42 is some other matter.
42, no?
Mr. Mahapatra is appearing
No,
in a
no,
number of
this
cases
is
in the
we are in
therefore he is
42.
getting confused. There 42 also, Milan. I am for
42,
the.
you are also there.
Yes.
You are also there.
42.
42.
Not account.
Report is in 42, no.
Royal College.
Huh?
Royal College.
Report is in 45 probably.
That's if is correct.
Yes, Mr. Acharya.
My lord.
Yes, what is this case?
My lord, this case in fact pertains to the building, my lord, of a college, private college that is located just by the side of High Tech College. That they said that it was within the BDA, but earlier it was within the Panchayat area. So Panchayat has already given no objection for the construction plan approval, etc. But the subject matter of this case, my lord, that
Yes, continue.
Lord, I'm sorry. So that is pending before the Honorable Supreme Court, my lord. Jagdish Patnaik versus my learned friend must be aware of it. So I think, my lord, your lordship may take up that after the disposal in the Supreme Court. Lord, that SLP I am giving the reference.
Dispute involved here in some other matter.
In special leave number 26071 of 2012.
Please
In
repeat.
fact, my lord, sir,
I am giving you.
in fact, I have not got that file. In fact, I have not brought this file. I have missed it.
Asu after vacation, after the disposal of SLP, Asu.
Yes.
Disposal of the
SLP.
SLP, I think may not be having any connection in respect of this.
No, absolutely.
Maybe take it out after vacation. I will
Same
check it
matter.
up and then I'll see.
Yes, feeling that it is
Now,
not
probably DN Holmes case. My lord,
Yes,
friend is referring to
the
DN
same
Holmes case.
issue.
But there the interim order is very difficultly couched.
No, maybe, but that's the same case. You have permitted one builder to do, one college will not
Some
there.
of the disputes involved herein appears to be, claims to be.
No, I agree with
In SLP,
26071 of 2012.
it is better to hear this matter after the disposal of aforesaid SLP. Parties are directed to bring to the notice of the court the outcome in the SLP so and so. Immediately after disposal of the same. Interim order achi kichi?
Milord, interim order is there. Interim order is there.
Okay. But it was at show cause level. You could have given a response and the matter could have been
So in
resolved.
the meantime, my lord, there have also been development. Now the
now
irrigation
that
department has already
If
given.
my lord please to take up it after vacation, I think I will bring any subsequent development, whether he has applied for the administrative scheme, regulation scheme and all these things. Because
Everything
so
has
far
been
my knowledge
File-
goes,
You file any additional affidavit in the.
no, I will bring it. If my lord please, so far Supreme Court decision is concerned, may not be squarely
You may
covered.
bring an application.
I'll bring that up.
First, bring any material there to help you, then thereafter, you may file an application.
Yes.
It may not have nothing to do, it may have nothing to do with the other case. All right. Interim order to continue. Yes, no other case will be taken up today. What I call 44.
What is item 50 is election.
44.
Election starting as a state lot. Lordship specific posted today.
Sir, 49 your lordship directed me to be present in 49 to shut down that.
43 ସବୁ ରହିଲା ସେ ପୁଣି ଆସିବ ସବୁ 44 will go out. Yes.
Item 50 lot.
44 interim order to continue. 43 ଏଗୁଡା ସବୁ after vacation ହବ ଗୋଟେ week ରେ ଦିଟା matter ରଖ after vacation. Interim order wherever there to continue.
45 short, it is a very short matter. 45 but immediately after. No, aji mo kohuni. Mo aji kohuni after vacation.
ସବୁ after vacation.
Oh, sorry, 46.
ଆମେ ଗୋଟେ working week ରେ ଦିଟା matter ରଖିବୁ.
ହଁ ଠିକ ଅଛି. Please.
Any interim order wherever continuing to continue. Pending ବହୁତ judgment ହାତରେ ରହିଛି ଆମେ ସେଟା clear ନ କଲା ପର୍ଯ୍ୟନ୍ତ ଆଉ reserve କରିବା ସମ୍ଭବ ହଉନି.